Justices of the Appellate Division Court Department. Hear ye, hear ye, hear ye. All persons having business to be before this court will draw near to their attendance, and they shall be heard.
Good morning. Please have a seat. Welcome to the Fourth Department. Just a couple of reminders. I see a number of our regular customers, but for everybody else, the judges make a real effort to know the record and know the facts. And so we don't need to know recitation of the facts. I'd ask that you get right into your argument. And to the extent that it's fair to your clients, get right to the key arguments would be useful. Remember too, that we don't allow rebuttal. Well, with that, we'll get started. The first case for argument is number 455.
Good morning, Your Honors. My name is
morning.
Dan Coleman, and I represent the respondent National Grid in this EDPL.
You're all by yourself today, sir.
Yes, Your Honor. Petitioner has chosen to submit. I represent the respondent National Grid in this EDPL 207 proceeding, which seeks to annul National Grid's determination and findings. The determination and findings complies in all respects with the eminent domain procedure law, the State Environmental Quality Review Act, the Transportation Corporations Law, and the U.S. and state constitutions. As such, it should be confirmed the petition denied and this proceeding dismissed.
Okay.
National Grid is a public utility and a gas and electric corporation under the Transportation Corporation. Yes.
Tell me just a little bit about this process, of having a hearing before the company instead of like an agency or a government, that I just didn't understand how the hearing went to the entity that it went to.
Yes, well, the Transportation Corporations Law specifically confers the power of eminent domain upon gas and electric corporations. National Grid is a gas and electric corporation, and the TCL further states that when it exercises the power of eminent domain, it has to comply with the requirements of the eminent domain procedure law.
And have a hearing in front of
Yes.
the utility.
No, the utility conducts the hearing
Okay.
because as an agency would under Article 2 and complies with the same requirements that an agency would under the eminent domain procedure law. It's just the utility is the condemnor instead of the
Right.
agency.
And I have no problem with anything else. I just didn't really understand, the process. And you just made it clear for me. So I'm good.
Yes. So as a gas and electric corporation, National Grid's core purpose, responsibility, and obligation is to ensure safe and reliable electric service to the many homes, businesses, and public facilities located in its service territory. The Appellate Division and its original jurisdiction over these proceedings has described that as a public duty.
This has got to be one of your easier cases. I mean, we had a very severe problem that happened here that the public needs to be protected from, and that's what I think you aim to do here in this proceeding.
Yes, Judge, I would certainly agree with that characterization. In fact, the corporate purposes described in the TCL, which is the scope of eminent domain authority that a gas and electric corporation has, describes the exact activities that are being undertaken in this public project, which includes the replacement and relocation of existing utility infrastructure. And I would point to Neptune Associates, the case that we cite from Second Department in our brief. It interprets that provision, the corporate purposes described in that provision.
That seems to be almost directly on point to this situation, right?
I would 100% agree with that, Your Honor. Absolutely. And, I think in that case even goes further, which it expands the interpretation of those corporate purposes to functions inextricably intertwined with the activities described therein. The court doesn't need to go that far here. The exact activities in this project are described in the statutes. So, and that's, the record's uncontroverted. It's details a long history of marina operations and practices, which are creating safety issues for those present at the marina.
Primarily what you're doing in this process, as I understand, it has to do with two distribution lines, correct? Essentially, you're putting one underground and you're heightening, for lack of a better word, the other.
Yes.
And then you need to make sure you control the easements underneath. And you're saying that that has a public purpose, that there was no violation of the statute with respect to notice and the other contentions you all have refuted in the brief, correct?
Exactly, Your Honor. Yes. And it is a clear public purpose. We're going to be constructing a barrier protecting the electric facilities there, which separates the easement area versus National Grid's property, or remaining property, excuse me.
No, it seems like the petitioner herein is arguing that this taking is going to interfere with their ability as far as their north and south parcel of the property. If you're cutting off, you're gonna cut off access to them, and this has been a family-owned marina. You know, there's many, obviously, many public patrons who utilize the marina, and basically you're cutting off their income and you're gonna close down this particular marina, and your actions are heartless. And
Yes, Judge, I certainly wouldn't agree with that last part, absolutely, but they are arguing that. And I would point to the project, which, specifically reserves for them rights necessary to continue to operate the marina. There's really two parts of the easement area here. One is the wraparound road, which is a little closer to the electric utility facilities. That's going to be limited to ingress and egress. That was actually constructed in violation of the existing easements.
On that point, you've preserved their ingress and egress, correct?
Yes, correct. And then the part of the easement area closer to the water, they're going to maintain a lot of the rights they originally had, which is to flood, dredge, repair the retaining wall.
did you have access already to the portion of the property your property, rather than having now to take access on that road?
Well,
Or is it more convenient for you to do that?
It's not an unfair characterization, but they have to also, when National Grid is maintaining and repairing its facilities, it involves a lot of equipment, trucks, things like that. And there's a driveway there. And I would point out that National Grid also owns part of that driveway and grants to the petitioner an easement, access easement that they use themselves. And that right is being reserved to them here. This is all about efficiency and serving their core public purpose, which is to maintain efficient and reliable electric utility infrastructure, which serves town, the marina, and the surrounding area. So, they're better able to serve that purpose by obtaining that access easement on the driveway. I'd also point out that, it's our position that they already have it. There's, as a, utility under their tariff, they are allowed to access any property in which they have, utility infrastructure if they deem it sufficiently emergent situation to address the, the issues there.
So you raised the distribution line, is that it?
Yes.
Purposes, because, they were moving boats and things like that in between.
Yes. So that was
One individual got electrocuted and died, right?
Yes, and that would actually be distribution line number one, which we're putting on the ground. The one you're talking about is over the water, which makes it difficult to put it underground. So we're raising that. It's a lower elevation under there. It's really just to correct what we deem an unsafe situation, and the property interest is to be acquired here are pretty minimally invasive in terms of the temporary easements, and the permanent easements are standard utility easements necessary to maintain and repair the utility infrastructure there.
Thank you.
All right, you got anything else in your brief? We'll take a close look at it, Council. We appreciate your efforts very much.
Understood. Thank you for your
Thank
time.
you. And I forgot to announce that Justice Greenwood is recused on that case, which is why he hasn't joined us, but he's going to join us now. You're all set, sir. Thank you. Next case for argument is number 445, People v. Smith. People v. Smith. Curtin, good morning, sir.
Good morning.
And you're all set to go.
Thank you, Your Honor. May it please the court, Harmony Keeley on behalf of the people.
You're not used to going first,
I'm not.
but go right ahead. I want to let you know the panel has drilled down on the facts and the sequence. We know the facts very well, and we'd like to hear what you think your primary arguments are.
Thank you, Your Honor. The lower court erred in determining that the people had not filed their initial COC and statement of readiness with due diligence and good faith. And in addition to that, the lower court erred in issuing the sanction under 24580 of dismissal. And I understand that defense counsel has raised that was a motion that the people brought, and I would like to address that part first. So the motion that the people brought following the initial decision when the court was issuing the sanctions The court initially indicated that the sanctions would be preclusion of the text messages that had some deletions in them, as well as preclusion of any testimony regarding those text messages, which, as this court knows, was the core of the case because it was a dissemination case.
We've written a lot on this subject matter in our court in particular. You've seen these cases, right?
I have.
And I forget the timing of it, but the Walker case, there were two.
Mhm.
I'm talking about the more recent of the two. You're familiar with that case?
When you're saying, I'm familiar with
It
the.
wasn't very well done, was it?
It's
Walker
okay.
cases, which one? But I'm talking about the one where we defined the possessory prong and the
Yes.
relevancy prong.
Yes.
And as I understand it, your primary argument, and I'm not trying to do away with your other arguments, but is that here, these deleted text messages never met the possessory prong because at no time were they in your possession. They were in the possession of the defendant and the victim at some point, and she deleted them before you even knew they existed, correct?
That's correct, Your Honor. And that is, the core of the argument here is that we were not in possession of those messages. And the lower court invalidated the COC and struck the SOR based on those, based on the deletion by the victim of those text messages. The people in exercising due diligence, and when they found out that the phone records didn't match what was in the actual printout of the text messages, went and spoke directly with the child victim, drove to Niagara Falls, and determined that there were some that were missing, immediately disclosed it to defense counsel.
The court seemed to be troubled, at least from my perspective only, that when the DA started putting together the proof for trial, discovered that these were missing, were out of order. So you matched evidence apparently, and the sequence didn't match up exactly, that you could tell something wasn't right. So you investigated that, and then you immediately brought it to the attention of defense counsel. But even though you did that work, you could be faulted, I suppose, for not doing your trial preparation a year in advance, but that's not realistic. But under our Walker case, which I've got back on the screen here, it simply doesn't meet the possessory prong.
That's correct, Your Honor, and that's my argument exactly. I think the child victim in this case falls under the same category as the Department of Corrections, that they're not under our direction and control. We would never have possession of the text messages, and so it could not have invalidated the certificate of compliance or statement of readiness. And then just briefly talking about the sanction was issued to preclude and then later changed to dismiss, and that the review of the sanction was pursuant to our motion, but that the final court order incorporated its initial order striking the COC and the SOR and simply revised its level of sanction, and so that we could appeal it. And she indicated that that was based on a misapprehension of the law. She wasn't trying to insulate her decision from appellate review. And I know that in his brief, they have raised that it was on our motion to dismiss, but that's not exactly correct. It was on our motion to review the sanction. And it was the entire order that we're appealing now, including the original one. And just briefly with respect to prejudice, I think that it is very hard to establish prejudice, especially rising to the level of dismissal or the preclusion, which the effect would have been essentially dismissal, because defendant always had those text messages. And the prejudice that they're articulating.
But you know that even though the defendant may have had them, doesn't obviate your duty under the law.
Yeah, and I'm not
Right.
saying that it obviates our duty, but what I am saying is that the argument as to why he's indicating that he's prejudiced is because had he known they existed, he could have asked for a forensic review of the phone, or he could have subpoenaed the content from T-Mobile. He could have done that anyway, because he was a party to the conversation and he knew what was there. And if there truly were some messages that would have enabled him in any way, he always had that ability to do that. It wasn't the people determining that they were deleted that triggered that prejudice. He always had those messages. He always had that ability to make those requests for evidence. And if there's nothing further, I would rest on my brief.
Thank you. Counselor, one thing I was doing while up here was taking a look at the Walker decision that I referred to. And that was issued by our court in late November, early December 24,
Yes,
which
Judge.
was right before the court's decision here.
Yes.
So it'd be unrealistic, very honestly, for the court to be necessarily aware of that. But that's really what's on my mind, at least, that, I was on that panel.
Yes.
And I've been on a lot of other panels where, I don't think we made up the law at all, but we gave it nice structure, in my view. Of course, I was on it, but we defined the possessory prong and the relevancy prong. And we derive that directly from the language of the statute vis-a-vis automatic disclosure.
Yes.
So what I'm really stuck on for your argument here is in light of that Walker case, and we've cited it many times since for this, I think that's where you're running uphill from my perspective. Tell me how this meets the possessory prong, or maybe you tell me it doesn't need to.
Judge, if I may, Paul Curtin on behalf of Jonathan Smith. Indeed, the possessory issue is important here. However, I think there are some facts that distinguish the two cases. In particular, to state that they were not in possession of the texts is not true. They had the texts and they were informed at grand jury that there were gaps, deletions, and rearranged portions of those texts.
Well, when you say they had the text, they didn't have these particular, they had texts. Isn't that what you're saying?
Well,
Not claiming they had the texts that are issued.
I would say that
The very specific texts that were later disclosed.
yes, Judge. They stated that they had the texts sufficient to bring this case against Mr. Smith. Mr. Smith said, this is not the original conversation. In other words, what he said was the thing that they were presenting wasn't what they said it was. So it's almost as if what they had was evidence that they thought was sufficient to move forward with the prosecution. And he's saying it's defective. The data is incomplete, as it were. So I'm not really sure to say that they're not in possession. Generally, the cases that talk about possession talk about an actual full item of evidence that is not in the people's possession. It's a very different thing. It's almost like having degraded DNA.
To make this argument, maybe I'm missing it. If I am, please tell me and explain it to me. But it seems to me to make the argument to distinguish Walker, you'd have to say essentially that the people, since they had these text messages, whatever they were, and the defendant testified they were out of order, out of sequence, etc., you seem to would have to argue that the people exercised deliberate ignorance. Is that your argument? And do you agree that you'd have to show that to win on that distinction?
Your Honor, I would not use the word deliberate myself. However, I would say, indeed, they found out at grand jury that there were problems with this information, with this data. They then didn't ask the complainant about it until the week before trial.
They did ask the mother, and it was the mother your client accused of being the one of the IT person, whatever the language was,
Correct.
right?
Of course, there's also a sort of a series of factual issues there where Mr. Smith made comments that he thought the mother did something with the data. The people didn't think that the mother had anything to do with the process at all. There was also an instance in September when they investigated some TikTok texts, and at which point they talked to the complainant about them, and she admitted that she had deleted some. So they were on notice at least as early as September that this is someone who was willing to destroy evidence.
But by that point, they were deleted, correct?
Pardon?
By that point, the text of the subject matter of your motion had already been deleted by the complainant.
Correct.
Okay, so even if they'd done something in September, the toothpaste couldn't be put back in the toothpaste.
That's correct. You
right?
know,
So
by October, my understanding is that the data was gone in a universal sense.
early on, right?
Right.
Okay.
However, I have to agree with the court below that the reasonable, diligent thing to do would have been immediately after the grand jury talk to the complainant, which is what they did not do.
So we might agree that there was a lack of diligence here. But I guess Justice Curran is trying to say, how do we get past the fact that they didn't actually hold them in their hands, these text messages?
Well, I guess I have to circle back to my idea that they claimed they had all the data they needed. They were told that it was defective. I'm not, this would allow parties to completely ignore and would be able to, in a purposeful manner, not investigate.
Well, that's why I think you might need to prove that in this circumstance, since the deletions were already gone. That is, if they had any sort of notice inquiry, that they should go to the complainant and say, preserve these at the time before they were deleted. And they didn't do that, then you'd be in the game. But I don't see that argument being made here, correct?
Well, I think that is the case, Judge. I think when they presented the evidence at grand jury, you had an individual saying, this is there are sections missing, there are sections rearranged, this isn't the original conversation. So I think they did have notice that there was a problem, unless there was some reason for not presenting the data at grand jury in the manner they had.
They don't have to present all their proof. That's a separate issue.
Correct.
I think we have your argument, Counselor, but I want to cut you off at all. We focused on the cases. What else?
Judge, if I may, I would like to return to the issue of the sense and the language of the order dismissing the indictment. The judge, on the record, the very last sentence in her order is, "I am dismissing this pursuant to your motion." And for that reason,
This is the aggrievement issue you bring.
So we are asking the court to consider the fact that having successfully moved to dismiss their own indictment, the people cannot bring this appeal and it should be dismissed. Thank you.
Thank you very much. Moving next to number 446, excuse me, People versus Bordes.
Good morning, Your Honors. May it please the court, Phil
Good morning.
Rothschild, Hiscox Legal Aid on behalf of Amir Bordes. The first issue, there's only two, that I would like to address is the transferred intent. That charge deprived Amir of his right to notice and due process. The indictment alleged Mr. Bordes' specific intent to kill Mr. Gilliard, and that was reiterated in the bill of particulars response from the co-defendant. Defense counsel objected to the transferred intent instruction that was granted after the close of all proof, noting that it changed the theory of the case. Now, where the prosecution specifically narrows its theory of the crime, the court is obliged to hold them to the narrower theory alone, as I believe this court said in Duel. Only the grand jury determines the charges, and this court reiterated that in People versus Reed. The proof at trial, varying from the indictment, compromises both the grand jury's authority and the defendant's right to notice. Now, criminal intent is always a material element of the crime. For murder, mens rea can be either intentional or depraved indifference, but they are mutually exclusive, as the Court of Appeals said in Feingold. The latter, though rare, clearly applies where a person fires shots into a crowd of people, such as we have here. In contrast, there was no proof presented that Mr. Bordes knew Mr. Gilliard, let alone had any intent to kill him. Now,
Can I interrupt real quick, just so I get this question out of the way? Would your argument be the same if the indictment alleged or of a third person?
I believe, Your Honor, that doesn't necessarily change things because the focus of the people was that this was a specific intent, and the focus of the defense throughout was you didn't know him. I mean, you look at the cross-examination, you look at the closing statements, you look at everything. Everything was directed towards this is a specific intent case, specifically intended to kill. Now, as far as
But if they had alleged or of a third person, track the language of the statute, they would have at least put you on notice of the possibility of hitting somebody other than the so-called intended victim.
I think it's problematic insofar as that even with, transferred intent, the people cited a case, People versus Black Shell. You still have to have the intent to shoot one person in order to have that intent be transferred. And in Black Shell, they specifically said, look, he was shooting at what he thought was an enemy and in fact shot someone else. Here, there's no indication of any type of relationship or specific intent. And that is the problem. To say that he intended to shoot one person or another when you never establish any specific intent whatsoever, I think is problematic. Under 200.70 of the CPL, by the way, this transferred intent has been found in a number of cases to, in fact, represent a change in theory. In Calderon, it was ineffective assistance of counsel by not objecting to it when it was not charged in the indictment. In White Cloud, the court denied relief only because it was not objected to. Here it was objected to. Under 200.70, amendment may not change the theory of the case or prejudice the defendant. We submit that there was ample proof of prejudice here because the defense was focused solely on this specific intent. Not allowed to cure legal insufficiency of the facts. We submit that, in fact, these facts were insufficient. This probably should have been charged as depraved indifference, but it wasn't. Defendant also must be granted any adjournment necessary to prepare. Here, that was actually impossible because this was done after the close of all proof. The instruction made it likely that the jury convicted on an unindicted theory usurping the grand jury's role. Moreover, it prejudiced Mr. Forties as the belated and Denman made it impossible to respond. We will submit that reversal is warranted on that basis. The second issue I'd like to address is the poll camera.
Is what, Ms. Roster? I'm sorry.
Poll camera,
Thank
poll
you.
camera videos. Police and prosecution failed to comply with mandatory disclosure, essentially hiding the videos and not notifying the defense of their possible existence until the eve of trial, long after they had been destroyed, thus violating their duty to preserve evidence under 245-55, subdivision 3. Now, the police.
But you have to have something to base your argument on, that this video would have shown something about the third person in the car. I know begins with the E, I've forgotten his name, but
Ellerby.
thank you.
Mr. Ellerby. Now,
That was what you argued was.
Yes.
Right?
Well, given the fact that Mr. Ellerby was a next door neighbor of Mr. Bordes, I believe they lived across the street from each other. I believe Mr. Ellerby said, I never hang out with this guy. This is like one of the few times I actually ever met him. This camera was put up a month prior, and I believe it was not taken down until several months afterwards. Any type of video showing Mr. Ellerby associating with Mr. Bordes, Mr. Ellerby associating with known gang members. Remember, this was, they took out of literally thousands of hours, they took approximately, maybe a couple hours, and they used 10 minutes of snippets. They essentially cherry picked what they want. To say that there would have been nothing, I believe that is speculative, Your Honor.
You would have access to some facts either from the client, trial counsel would be from the client, from co-defendant, anything that, some fact that would say, well, we have reason to believe that Ellerby was doing this on such and such date or something, to be able to support, other than the speculative claim that, well, he must have been on the video. That's what bothers me about the claim, is that, oh, he must have been on the video, but there's nothing on the record to support that speculation.
Well, given the fact that it was basically, the camera was pointed in the area between their two houses, to say that he was never on the video, I think that's speculative. More importantly, I think that Mr. Ellerby, said that I have nothing to do with this. I don't know this guy.
Did the prosecution say that he was never in the video?
No, I don't believe they said that. But, any type of association, that alone would have been impeachment material in the hands of a zealous defense advocate. And that was a decision for the defense advocate to make, not the judge and not the prosecutor, because that's the way it works. The value, the impeachment value of something is determined by someone who has a single-minded desire to do that. We would submit in this case, they installed the camera, they expected this, they had the duty to turn this over, they turned none of it over. And to claim that it's speculative essentially ignores the possibility, and I would submit the very real possibility, because remember, Mr. Ellerby also said his account was very much impeached during trial. He said he couldn't remember how long he was in the car, why he got in the car, whether he went back to his house or not, what they were going around doing, things like that. As far as even the facts of how this thing went down, any type of impeachment of Mr. Ellerby certainly could have been very valuable to tip the scales, because the case rested to a tremendous degree upon what he said. Sanctions were required in this case under CPL 245-80. When the discoverable information has been lost or destroyed, the court shall impose an appropriate remedy or sanction with substantial prejudice. Unlike under 240, substantial prejudice is not required. We would submit the matter was preserved by timely objection and notice to the court. The people in this case displayed the very antithesis of due diligence by hiding the video. The error was not harmless and reversal is required.
Thank you, Counselor.
Good morning, Your Honor. It's David Bassett for the people. I'm just going to pick up with the poll camera issue. It's our position that these videos, the only relevant videos, were properly preserved and disclosed. And those videos that were relevant were the ones immediately preceding the homicide of Gillard on July 13, 2019.
But doesn't counsel bring a good point up? That is, you've got that many hours of video. Ellerby had to be on it somewhere, doing something, right? Isn't that a good argument?
Well, yes, he lived there, Your Honor.
Right.
There was no indication to believe that he was doing anything criminal. He has no criminal record. There's only one indication in the police reports that he was on the street after a shooting in which he was not a suspect, and he simply went home. That's where he lives. The poll camera was set up a month earlier in June of 2019. And defendant's theory is that we should have been preserving, or the police should have been preserving that video all along, but there's no reason to do so until the crime on July 13th, a month later. Those videos are not routinely stored and preserved. They are only preserved for a short time. Therefore, when the crime occurs on July 13th, we look back to what's available and what's relevant. What was relevant was what happened immediately preceding the crime. And we turned over hours of video from July 12th into 13th, which captured the events on this street, Shirley Drive, and showed Mr. Bordes going in and out of his house, Mr. Everson picking him up in his vehicle or his girlfriend's vehicle, and Mr. Ellerby getting into the vehicle at one point, and then them all returning later and dropping off Ellerby and Bordes after the shooting. There was no indication that there was anything in the videos preceding July 13th that would have incriminated or implicated Mr. Ellerby in some way that could be used as exculpatory material under Brady or impeachment material under CPL 245. People had no obligation to preserve that video in that month previous, and no obligation to turn over additional videos that were unrelated to the subject matter of this case, the homicide on July 13th, 2019. Everything else the defendant was asking for is purely speculation, and that's what the court ultimately found. Turning to the transferred intent issue, it's our position that instruction to the jury did not change the people's theory of the case. People's theory of the case was the defendant intending to kill caused the death of Jamir Gillard. The identity of the intended target was not a material element of that crime. Therefore, the instruction given by the trial court to the jury did not vary from our core theory of the case. And that is what, if you want to talk about Duell and some of the other Fourth Department cases, Rivera have said, essentially, if you charge more than the indictment, then the crime requires under the statute, under the penal law, it's not improper to give the jury an instruction which tracks the language of the statute, the penal law, so long as you're not varying the material elements of the crime. And that goes back to Court of Appeals case law and People v. Flanders, People v. Charles. And that's our position. There was no change in the material elements of the crime because the identity of the intended target is not a core material element of murder in the second degree. And that Third Department has reached the same conclusion in People v. Lee. And our position is that there was ample evidence to support a specific intent crime because Mr. Bordes was wounded 2 days before this Gillard homicide. He was in an ongoing feud as a person who lived in the Valley area versus people that lived in the McKinley Park area where the homicide took place. He goes to that McKinley Park on July 13, 2019, and he and Mr. Everson fire 11 shots into people standing there, killing Gillard. Both that motive and that action suggest a specific intent to kill someone in that crowd. That could either be Mr. Gillard or that could be someone else in the crowd, and the intent is transferred to Mr. Gillard. Therefore, this was a properly supported theory which did not vary from the core theory that we alleged in the indictment. Thank you.
I think we have that. Thank you very much. Moving next to 447, People versus Jones.
Good morning, and may it please the court, Aaron Friedman for Justin Jones. Unless the court has questions on point 3, I'll be focusing on point 1. In MS,
This is the video.
This is the video, that's correct.
MS, you know that our court is well familiar with MS.
That's correct, and I know, Justice Presiding, that you were in the dissent in the GH case. But in MS, the Court of Appeals reaffirmed what it said in Patterson, that video can be authenticated in 3 ways: by a maintainer, installer, or operator of a surveillance system, by a witness to the events depicted in the video, or by testimony, expert or otherwise, that what appears on the video accurately represents what was in front of the camera. Now here, technician Kaltenbach, who testified that he wasn't sure whether there were alterations or deletions to the video, was none of these 3 things. Moreover, the people don't argue he was any of these 3 things. Rather, they argue the video is properly authenticated because he testified to the steps taken to download the video. But they provide no case law in support of so-called steps taken testimony. And this court has never held steps taken testimony to be sufficient.
What's chain of custody? Another way to look at it, isn't it?
So
Steps taken, chain of custody now?
yes and no.
Okay.
So chain of custody comes into effect once the video is in the custody, I would say, of the police. But that doesn't necessarily mean what steps were taken to download it in the first place. So one of the reasons why this court shouldn't endorse steps taken testimony is that at most it can testify, if there are no chain of custody issues, that the data introduced at trial is the same as the data that was downloaded. But that doesn't mean that the information contained in that data itself was accurate. So it's a little confusing in the case of a video, but much more straightforward if you think about like a Microsoft Word document.
But he testified more than to chain of custody. It was in the testimony that, based on his observations, the video had not been tampered with. Am I on the record?
No, Your Honor, respectfully, he testified that it didn't appear to him only based on viewing the video, but he also testified that.
So he did testify.
Well, not that there were no alterations. I mean, he testified he wasn't sure if there were alterations or deletions. He testified that based on.
He opined that.
Well, based solely upon a superficial viewing of the video, that on the watching experience, that there weren't jumps or skips. So there was nothing sort of obvious when watching it. But if, reading the Court of Appeals' decision in MS, in the background, artificial intelligence deep fakes are much more common than in Patterson.
So your argument is that it wasn't, his testimony wasn't sufficient as to whether the video had been tampered with, because he did address it and he said that in his observation it wasn't, but you're saying that wasn't enough. He should have gone deeper.
It wasn't enough for a few reasons. In the first instance, Patterson, MS explain what testimony is sufficient. If you take, aside from those 3 methods, what Patterson and MS are trying to get at is the question that Your Honor is addressing is, has this video been tampered with? In which case, at a minimum, someone would need to testify that there were no alterations or deletions and that the person has knowledge of this. And here, the officer candidly said he did not know whether there were alterations or deletions. So aside from the Patterson and MS methodology, just looking at the question of is there tampering, here that was not sufficient based on Kaltenbach's testimony that he didn't know if there were.
By the way, I was on the other side that the dissent agreed with me on that, but just.
That's correct. You and Justice Bannister. Yeah, I've been.
Justice Presiding's correct.
I've been rereading
Do that, Justice Greenwood, but thank you. But seriously, Counselor, it's an interesting case how it came timing wise. These things happen for us. MS comes out, and then next thing you know, we're working on this report. So it is, at least from my perspective, and I think everybody else, it's fascinating. But I look at Chief Judge Wilson's opinion in MS. A lot of where he's distinguishing what the dissent said in that case was he focused on the origin of the video. And there, the origin of the video had a lot of suspect issues, according to his writing, as I understand it. That is, there's primarily that 2.5-year gap, as I recall the time frame, between when it was purportedly recorded or downloaded, I suspect, by the child pornographer or whatever he was, and the person was under FBI investigation. But here, I don't see the origin as being in doubt. You have the technician arriving within an hour of the crime. As I understand the technician's testimony, and this is what you're up against, I want you to be able to have a fair response to respond to it. He confirms that the system is in working order. observed that the video recording was on the monitor, compared the monitor on the video and the scene he had just walked through. He checked the live view to make sure the system was working properly and that what he was seeing outside or through the video, it was actually occurring at the time. None of that was present in MS. And of course, he checked the timeline, the date was correct, the hour was off by an hour, and then he did the download. To me, that's critical distinction between this case and MS. What do you think about that?
So Justice Presiding, I think there are two issues. I think one is general to police downloading surveillance footage, and one is unique to the facts of this case. So as to the general principle, testifying to the live view only testifies that what you're seeing on the screen is accurate in that moment, doesn't mean without further testimony that what happened an hour, a half hour, 2 hours ago, whatever the case may be, whether that accurately recorded the events at the time. Now, I could imagine more testimony about a particular type of surveillance system. For example, I know this is a Ring system. I know that Ring data can't be altered if you download it directly from a particular server. I don't know if this is the case, just as an example. If there were further testimony about that, it could potentially be sufficient, but that's not present here. Additionally, as the cases discuss, forensic testimony, expert testimony would be sufficient to say that the data was in fact not tampered or altered with in any way. Now, as to the facts of this specific case, the issue, in addition to Kaltenbach's testimony about not knowing if there are alterations or deletions, is the fact that he leaves a hard drive in the store and a hard drive gets picked up the next day. Now, in my initial brief, I incorrectly wrote that there was no testimony. It was the same hard drive. Kaltenbach testified that it was the same hard drive. He had no firsthand knowledge of this because it was Ferguson who picked it up the next day. So there was nothing like I dropped off a hard drive with such and such a serial code on it, and then Ferguson said I picked up a hard drive with such and such a serial code. And Kaltenbach testified that he left the hard drive unattended in the store and that employees of the store would have had access to it. So there's really two issues where tampering may have occurred. One, was the video authentically recording what was happening in the first place? We have no testimony about that. And it is possible if, for the case of certain apps have live videos where you could, for example, record a live video showing all of your honors wearing the same tie that I am. You could put that into a filter. So the real question here, because the only way that Mr. Jones' identity was established was from his screenshot being in the video, was he actually in the store, or how did he get in the store in that video?
Counselor, let me interrupt you so I don't forget to mention this point. It's taking you back a second or two, so bear with me. But looking back at my notes, I think it's page 21 of the transcript. As I recall, there was voir dire that occurred, I think with Kaltenbach, whatever his name is. I thought he testified, and I think this is following up on Justice Greenwood's question. It doesn't appear to be any change because the time frame rolled through and there were no skips or changes to the time as the time it was playing. Isn't that proper foundational testimony with respect to they could not observe that there had been any alterations to the video that they downloaded? And if you don't think that's not enough, why not?
I don't believe so, Your Honor. I believe the Court of Appeals does discuss the quality of the fake videos in the MS case. I believe there's a fairly thorough paragraph.
And they didn't have them.
What's that?
They didn't have them.
But in that case, they essentially say you can't tell whether it's real or not just by looking at it. So just by looking at what you see on the screen, you don't know if there's alterations or deletions. The way to know that is by some type of forensic analysis, getting someone to be an expert saying, I've examined the metadata, the information, this video was recorded at such and such a time.
Well, expert testimony would always be required under that theory, if I'm understanding you correct.
Their expert testimony is one of three methods. In terms of the
see where I'm
third
going, and forgive me for interrupting you again, but just so I can get it out so we can have this conversation. If you say that expert testimony is necessary to disprove any alterations or prove there were no alterations, that would require expert testimony in every case, because according to Patterson, the lack of alterations seems to be at least a potential element of the admissibility. Is that what you're asking us to do?
So I would respectfully disagree with Your Honor, because both Patterson and MS list the three predominant methods. One is a witness to the events. That's always possible. That would have been possible here in this case. Secondly, someone who's familiar with the surveillance system, the operator, the installer, the maintainer. And that's important because they can testify that they are familiar with this system and they know that if they download information from the server, from the hard drive, that information itself is accurate. That's the testimony here that was missing. I believe expert testimony is only necessary for the third method. If you look at Patterson, Patterson says testimony, expert or otherwise. After reading MS, I'm not sure how non-expert testimony could suffice under that third method. And actually, if you look at the Byrne case, which is, I believe, where Patterson gets this language from, in that case, it involves a still photograph, and there was testimony as to the negative. So I believe it requires some type of technical expertise. The level of that, I couldn't say, but you only need to have expert testimony if you don't have one of these two other methods, which we know that the people know how to do, because here one of the video exhibits was surveillance from a school, and it was properly authenticated by the security officer of the school, who was the operator of that surveillance system. So you only need that expert testimony if you can't get it in through one of the two other more common methods. The position is only that the officer himself can't testify without more. That's the general point. And then the more specific point is here, in addition to the lack of familiarity in terms of what happened prior to initiating that download, there is that gap in terms of what happened between that day and the morning when Ferguson picked it up. And based on just that second issue alone, this case resembles Patterson. In Patterson, the detective took the video from the store owner. Here, Ferguson took the hard drive from the store. Now, in that case, there were 2 weeks. In that case, the store owner downloaded it himself. But at least in terms of the idea of just going to the store, taking the footage, that's not enough in Patterson. In this case, is similar with that.
Okay. I have a question for you on sufficiency.
Yes.
As I read your argument, your sufficiency contention is premised on the inadmissibility of the video, Exhibit 1, correct?
That's completely correct. Yes. So the people relied on the video to establish Mr. Jones's identity. There was a still from the video, I believe it was Exhibit 54, in which he was identified by 2 police officers and a former parole officer or parole officer of his. Absent that still video, the still footage, the still image, which is a screenshot of this video that I'm arguing is improperly authenticated, there was no way of establishing his identity. So under Mangis, this court's, I believe, 2018 case, based without the improper evidence, the proof is insufficient. I would readily concede that the proof is sufficient with that evidence, but I don't believe the evidence is proper.
Thank you, counsel.
Thank you.
May it please the court, Bridget Field on behalf of the people. I believe this is a totality of the circumstances situation with regard to Officer Kaltenbach's testimony and Officer Ferguson's testimony to buttress that. Officer Kaltenbach talked about, as Justice Curran discussed, that he checked what was going. First of all, Officer Kaltenbach was at this corner store within an hour of the events depicted in front of the camera. So there wasn't, the passage of time that we have in other cases. He did the things, as he testified, that he normally does. He checked passwords, he checked usernames, he checked that the system was working, he checked that the things, or the view in front of the camera was what was actually in front of the camera at the time that he was downloading the video. He testified that he stayed at the store till about 2 or 3 in the morning, that he was the last person to leave the store. And then that Officer or Technician Ferguson picked up the video the next morning. Again, no big passage of time. There was, if I'm correct, I believe the testimony said there was about 8 hours of video, and that's why the download took so long.
Ms. Field, how would you distinguish Patterson that the counsel seems to rely pretty heavily on?
Well, testimony, expert or otherwise, we wouldn't have
You're in the other or otherwise category.
I am in the otherwise category,
Hence
Your
the
Honor.
totality of the circumstances argument.
Yes, it is, Your Honor. We wouldn't have that language or otherwise if expert testimony was absolutely required. I don't dispute that there are different ways that videos can be authenticated, to allow their admission. But I think in this case, we fall in the or otherwise, and that Officer Kaltenbach's testimony coupled with Officer Ferguson's testimony was sufficient. Officer Kaltenbach did testify that this was the same, whatever method, I don't recall, the drive, that it was the same drive that he had left at the store. He did testify that he reviewed the video and that there were no skips or anything that would have indicated any type of alteration. Again, I think in this case, it is the numerous factors that were testified to, including the timing, the location, the steps taken that constitute the or otherwise in this case.
And with respect to that, I think it's overnight where there's maybe an hour where somebody from the store might have had a key and then might have been able to access it. As I understand some of the case law, and I'm looking at the what has been very helpful, that guide, the evidence guide on the court website.
Yes.
Professor Utter and others put together.
Yes.
And one of the quotes there in the cites is gaps in the chain of custody go to the weight, not the admissibility. And there, when you have a relatively small time frame, we're going to have to evaluate whether that goes to the weight or the admissibility, correct?
Correct. And I believe that Justice Shiano, when he admitted the video, said his response to defense counsel's objection was that it went to weight, not admissibility. And in this case, Officer Kaltenbach was in the store until, I would say, the wee hours of the morning, and technician Ferguson testified that he picked this up the next morning. He picked the drive up the next morning. Officer Kaltenbach did testify that he was the last person to leave the store, that the store had emptied. There were no employees or patrons of any sort. Certainly, there was no evidence that his testimony was that he believed that an employee had a key, but there was no further testimony that anyone had any belief that this employee had in fact accessed the store in any manner. And I think that these are all factors that go to this court considering the weight, not the admissibility of the video. If there are no further questions, I would rest on my brief for any other issues. Thank you.
Next case for argument is number 449, People v. Williams.
Good morning, Your Honors. Lisa Gray on behalf of the people. I do note that Appellant has submitted on his brief. This was an important case to my office. I am available if the court has any questions for me. Otherwise, I would also.
I have a couple.
Yes, sir.
And I saw that you were going to be alone here today. But what I find very persuasive is that case called Morales.
Yes.
And, Morales has since been cited a number of times. In fact, we cited it back in 1989 in a case called Matthews. But one of the issues we decided there was essentially to agree with the analysis of Morales and say that the testimony should have been allowed. And Morales, just to state the obvious and reading the case, it's important because there was a voir dire. The testimony was excluded in toto, as opposed to going question by question in front of the jury, taking, breaks, things like that. There were other ways to do this. And just to have a blanket ruling of relevancy. And I see where the court was going, in fairness to the court, in terms of they can't testify as to the key time frame for the defense. But Morales addresses that too. So Morales is a case we're really going to have to look hard at. And it's a difficult case, I think, for your point of view.
Your Honor, I think in Morales, the court used some hedge words, and it says the offer of proof given by the defendant psychologist, this is in Morales, may not have been sufficient standing alone to overcome the presumption of sanity. And in this case, we had direct evidence with respect to whether or not Mr. Williams was suffering from a mental disease or defect on October 4th of 2019. There was the body-worn camera that reflected the events that were taking place. The jury had firsthand knowledge of the grandmother indicating what his mental illness was in October 2019. I believe there was a family member who was present there that day indicating to Officer Wright that—
Going through this, Ms. Gray, forgive me if I'm missing the point. Are you basically saying there was other evidence of his mental health and that should have been enough, but that doesn't address the in toto exclusion on the basis of relevancy, especially when it could have some impact on the requisite intent? But go ahead.
Sorry, Your Honor.
No.
But what Dr. Gibbons unfortunately couldn't testify to was that he couldn't draw that nexus between his diagnosis in 2021 and to whatever diagnosis might have been what Mr. Williams might have been suffering from in the events either in 2018 leading up to 2019. And I think that with that piece missing, I think blunts Morales's impact on this case, because Dr. Gibbons can only say, and defense counsel was fairly clear that she only wanted to call him as a fact witness. She was only going to have him testify as to what Dr. Gibbons' diagnosis was in 2021 during the time he treated him in RPC. And that offer of proof, and to Justice Renzi's credit, the conditional exam for that offer of proof was narrowly tailored. And Justice Renzi really tried to drill down in Dr. Gibbons' testimony. What were Mr. Williams' diagnoses in that time frame from 2018 to 2019? Was it the same?
Wouldn't some of the records from 2016 and 2018 demonstrate that he is suffering from these psychosis?
He was certainly, there's no question that Mr. Williams was a medically and mentally complicated individual.
And Dr. Gibbons did review those records, unlike the prosecution's expert.
And he did review them, but he could only tailor his testimony as to what his diagnosis was and what he was observing during that time frame of March of 21 to June of 2021. And there was no link between that proffered testimony and what was occurring with Mr. Williams in his mental health in the months and days leading up to October 4th of 2019.
But by precluding that testimony from Dr. Gibbons, that didn't essentially muster or handcuff the defendant, or he's unable to really muster a defense here?
Respectfully, I disagree. I think that
Doesn't he have a right to do that? Doesn't he have a right to put on a defense, a constitutional right, a fundamental right to put on defense, and this ruling from the judge basically curtailed that?
100% that there is a constitutional right to put on a defense, and the defense did that. He was not hamstrung.
Well, and again, wasn't this motion to preclude Dr. Gibbons like the day before trial? So what opportunity did the defense counsel then have to try and put something else together?
Well, I think, though, that was also addressed on the record by Justice Renzi, in the fact that there was proper notice given by the defense. This certainly was litigated heavily in terms of whether or not there were going to be experts called. Justice Renzi had urged all the parties, keep going with trying to get your experts. Let's get these reports in so either side can review them. So there was this wasn't an ambush by the people.
Sometimes an expert would be unavailable at that time for the defense counsel to retain and examine the defendant, so it really, all those factors together may have prohibited a defendant from mustering a defense.
I mean, respectfully, I do disagree based on this record.
It's okay. Take offense.
And I think the judge got it correct in this case with the offer of proof, and the limited testimony that Dr. Gibbons could offer would confuse the jury. They wouldn't understand for what purpose it was being offered of a diagnosis that had occurred I think the prosecutor on the record said something about 536 days after the events that took place. And for all the reasons contained in my brief, I would ask this court to affirm this conviction in its entirety. Thank you.
Thank you. Moving next to number 451, matter of Appellate v. Courthouse.
May it please the court, Tyson Blue on behalf of the appellant Sharon Gordon. Our principal argument in this case is the undue emphasis placed by the court on the child's academic performance in reaching a decision as to where he should reside and go to school. It was particularly put forth at the appearance on October 9th, where in regard to request to consider the child's wishes, the court stated, I'm only going to listen to that if it's a 12-year-old who's making really good grades. Later at the same appearance, in addressing the parties, the court stated, I'm letting both of you know that it's going to be heavily weighted by me in what decision I'll ultimately have to make. I want to see this child doing well academically. And again, in placing the decision on the record, it did state that for many reasons, but including but not limited to the child's academics, thus far at the Soda School District, and then proceeded to change custody in school.
Well, I think maybe your argument is too, or their argument could be made is that the family court failed to specify all the factors in determining the best interest.
That's correct, Your Honor. That's what I was about to say.
But we have the authority to look at this record if it's sufficient, then to determine whether or not those 6 factors weigh in many parties' favor that were specified in Fox.
Yes, Your Honor. I would note though that there was little, if any, information as to the relative merits of the 2 school systems or any.
Well, that may be so, but there was a lot of evidence with regard to the child's accomplishments at those 2 different school systems. You know,
Williamson and Sodas, or Sodas and Fairport?
Was doing better when he was with the dad and got better grades. And the father was able to help him in that regard. So there is, the record appears to show us that when the child is with the father, he was doing better academically when the child was spending more time with the father. And that was important to the judge. And it's important to us. Let's say if we look at all things being equal otherwise, okay, this is an important factor.
Yes, Your Honor, but with all due respect, he hadn't changed school systems yet at the time the case was going on. And there was also evidence of the extensive efforts by the mother to attempt to address his problems prior to the hearing, going to IEP meetings and arranging for extra help programs, the 21st Century program, and so on. Whereas
different emphasis put on education by different households.
That's correct. That also doesn't really take into consideration his relatively recent at the time diagnosis of ADHD, which would have had a profound effect on the child's ability to address his poor academic performance. And there.
But Mr. Blue, following up on Justice Banish's point too, my recollection of what I read in the record is that the father at least testified to far more diligence with respect to working with the child on homework, following up on it, and really paying attention to it. And I'm not sure I can fault the court for focusing on that emphasis on education for this age of a child. So I know that you're looking for, we look for error, and you're suggesting the error is the focus on the education. But that's a very significant part of the child's life, and that's a big portion of his best interest consideration. And so I guess following up with Justice Bannister, why isn't that emphasis on looking at how diligent the father testified that he was with respect to working child? Why isn't that a very persuasive fact?
We would submit that it's primarily because the mother also made efforts to address this, meeting with the school, arranging for a relative to tutor him.
But that hadn't, she testified, I can get my brother to come in and help give him some, but I don't remember seeing any testimony that she actually did that.
I believe the uncle did testify at the hearing as to helping the child with his work on at least one occasion. I believe more than that.
I mean, okay.
Counselor, circling back to what Justice Montour pointed out, even though the court emphasized in its decision the educational aspect, it did have like a catch-all phrase in addition to other, and as Justice Montour pointed out, we're not bound by that. We can go back, and wasn't there significant testimony by father about mother not bathing the child, and the child showing up several days in a row, same clothes, smelling, and not going, not having proper family meals, not having appropriate bedtime, not having appropriate recreational activity. Wasn't that all in the record?
Yes, Your Honor. That would note that appears. That type of evidence appears many times in custody matters, and how much weight it would receive should be considered in light of the specific facts of the case. And in this case, the emphasis was clearly on the child's academic performance.
And just to follow up on Justice Greenwood's question, didn't it seem like, at least from the father's testimony, about the living situation would be more stable, living with their father? He said and again, it is the father's testimony that he would show up at the house, the other house would be in disarray, it'll be garbage, vehicles scattered about the driveway, broken windows, doors, glass. And again, obviously, it's the prior effect to find out what's the best interest of the child based on the totality of the circumstances. So you're looking at the testimony in the record, as Justice Montour and Justice Greenwood said, it's a fair interpretation that the court can conclude this, correct?
That's correct that could happen, but we would note that in delivering its decision, the court only specifically mentioned academic performance, rather than bringing up any of these other matters that Your Honors have pointed out. So with that, unless the court has any other questions, I'll stand on my brief.
We're all set, Counselor. Thank you.
Thank you, Your Honor.
Good morning. I'm Cynthia Carroll for the respondent, Jeremy Billett. Really, the only issue before the court is whether there's a sound and substantial basis in the record for Judge Groh's decision, and there is. As the court was just saying, the appellant's primary argument is that there was a singular weight on Trey's academic performance to the exclusion of other factors. That's not entirely the case. Judge Groh's factual findings implicitly established some other factors. He made a specific finding that the mother's husband, who lived with her, had been convicted of 2 felony DWIs based on incidents occurring in 2 years preceding the trial, and that the stepfather's resulting incarceration had resulted in a financial crisis in the mother's home, and that the mother's unilateral and sudden move to SOTUS caused the child to not be able to attend school in Williamson for summer school for the summer of 2024, which is clearly not in this child's interest and clearly goes to factors of parental guidance, which parent is best able to support the child's intellectual development. I would note that the testimony regarding the mother's home, regarding the hygiene issues in her home, was largely uncontroverted. I understand what counsel was saying, that in custody cases, there's often he said, she said. This was he said. There was no she said addressing those points. Mr. Billett and his partner and his mother all testified as to his comparable good quality home environment, his activities and guidance of Trey's and the routines in his home. There was also uncontroverted testimony that prior to the litigation, it was Mr. Billett who was involved with the school, Mr. Billett who was going to the meetings, Mr. Billett who was getting Trey extra services. There was one IEP meeting while the case was pending that the mother attended by phone, wasn't multiple meetings, and father attempted to attend to that, but the school, for whatever reason, screwed up and didn't include him in that. It's also pretty obvious from the school records that the mother's motivation in the fall of 2024 was litigation. She repeatedly mentions litigation. Her inquiries in terms of Trey's homework are largely right before court appearances.
Counsel, let me ask you about the thing that probably weighs against you somewhat, okay? And that is that the child appears to be very bonded to mother. And I guess, I'm sure that's what the AFC is here to tell us, that, so what about that close bond with a child who now has a somewhat of a disability with the ADHD? How would you respond to that as a factor?
I would say one thing that, first of all, the pre-existing order from 2019 was a shared residency order where the child was actually with my client 8 days out of 14, and there was no allegation that there had been any problem under that order. He was spending a slight majority of time with his father. It was pretty clear from the father's testimony that father is very supportive of him having a relationship with his mother. There was also some suggestion of undue influence, right? When these petitions were filed, the stepfather went out and bought 2 ATVs. There was an Xbox that came into the house. This is a 11 and then 12-year-old child we're talking about when that's going on. Obviously, we're not privy to the in-camera interview, but there was never really articulated a reason why the child had the preference for the mother's house. And, there's a lot of reasons a child will express that through counsel. I mean, it could be that the child was worried about upsetting the mother. I mean, we don't know for sure what was going on that way. What we do know is that he was a relatively immature 12-year-old at the time of trial, now 13. He was getting in a little bit of trouble at school. He was mostly a good kid. He was doing things like following up his homework on the way out of class, getting a detention for messing around at lunch. This wasn't a child who, as far as I'm aware, was articulating real substantial reasons why he wanted to be with his mother as opposed to his father. And the allegation that he was particularly bonded to the mother and not with the father was really just self-serving hearsay on the part of the mother, as far as I'm aware. The court made a lot of comments about Trey and Trey's opinion, but in its decision, it made clear that the court considered Trey's opinion, that it did give it some weight. It conducted a Lincoln hearing. This is not a case where the court failed to give him a hearing in terms of his views and give that some weight. This is also many of the cases talking about the child's opinion. It struck me yesterday looking through them are cases where one parent is trying to change an existing relationship and the child is saying, no, I like the existing relationship. That wasn't the case here. The case here was that both parties had filed petitions that someone had to have primary residence. They weren't in agreement on the school.
Well, they both had moved, and then at the distance, 47 miles now, it's not insubstantial. Only one party drives.
Right.
We get it. It's a whole new situation than what we started with these folks.
So the only other points that I would make, and then I rest on my briefs, is that in terms of the emphasis on the ADHD diagnosis, neither parent thought that it was significant enough to warrant medication. The testimony suggested that it mostly just confirmed what the parties already knew about their child, and that some of the recommendations for accommodations were already in place with the school in terms of special placement. The child was doing poorly in non-academic subjects, which suggests it wasn't just the ADHD that was going on. And he was with his father on 3 school nights a month during this time period and with his mother the rest of the time. He had already been receiving interventions in Williamson before this case started. In reality, it's the appellants who would like this court to make a decision based on a single factor, Trey's opinion, and the case law is clear that his opinion is not determinate. Just a quick note, because I know that the attorney for the child has raised the Michael B. case that potentially there's new evidence that needs to come in. Based on the report cards that have been forwarded, including the most recent report card forwarded by my client, the child's doing very well. He's got an 82 average. His lowest grade right now is a 75. He's got a couple 90s grades. He's doing very well in Fairport, and that is not a basis to need to reopen testimony because there's something going on in the Fairport schools. I haven't seen that.
Great. I was going to ask that question of the AMC, but I'm glad you added yours.
And unless the court has any questions, I will rest on my brief.
We're all set, Counselor. Thank you.
Thank you.
May it please the court, Gary Muldoon for the child. This morning before oral argument, I stopped in at Martha Brown Middle School. It's down the street actually from where I live, and went to see the child and his guidance counselor. Because I've seen the child before at the school, not at their home, but at the school. And I wanted to confirm or change what his opinion was. And he repeated to me again that his preference was to live with the mother. I asked him why, and he said, well, it has to do with how his lifestyle is at home. He wants to be himself at home. He likes rap. His father likes metal. And that may be a superficial kind of a comment, but it's something that's important to him. And I have to say that his preference in music is entirely different from what mine would be, I hope.
So you're more aligned with the father?
You know, I'm a bit antiquated in my preference for music. The judge emphasized unduly good grades. And good grades are important. They clearly are important, but they are not the tail that wags the dog. Nor should this child's own selfish preference.
Can I bother you a second? It's not just good grades. It's passing as opposed to failing. It's not just 70s and 90s. It's, 80s and failing. We're worried about him failing.
Yes. And I should confirm what Ms. Carroll said, and that is that the child in his more recent attendance, more recent grades, including the third quarter at Martha Brown, has done well. It's gone up. But it's not a selfishness on his part. It's if you're miserable at home, but you're doing well in school, is that a good custodial decision?
So you're saying he's miserable at home?
He hasn't expressed to me happiness once in my time.
That's saying you're miserable. That's quite an extreme you're portraying here, so.
I may have overstated that, but his repeated comments to me have been that he prefers to live with his mother. He has a bond with his mother that, for whatever reason, does not exist with his father.
Well, there's other factors that need to be considered as well. The home, as far as basically, as Justice Greenwood indicated, home life at the mother's, not changing his clothes, not bathing, smelling. I mean, is that a preference that he wants? Is the financial aspects, the father can provide more. I believe it's, my understanding of the record is correct. His partner is a teacher as well, and she can assist the child with his schoolwork. And all those factors, maybe not specified by the court below, are factors that we have the ability, the court has the obligation to look at and determine what's in the best interest of the child.
I realize, and I certainly agree that this court can look beyond the words that the judge articulated and what he did not necessarily articulate, but looking at the entire record. I recognize that. So what I'm here is I'm coming here today to convey the child's desires, to convey his sincere desires. It's not immaturity on his part. He's in the 8th grade. He's 13 years old. He has ADHD on the IQ scale. It's not. He's on the lower end. He is, according to his guidance counselor, he is well liked in the Fairport schools. Gets along very well. Is not a loner. Does not really seem to engage in disruptive activities. So he's doing well there.
So why would you suggest Michael B. to us?
I'm sorry?
Why would you suggest Michael B. to us?
Your Honor, I think it's my obligation on any case to bring this court up to date. And that's why I wanted to have it as up to date as possible with this. And the grades that when I reported it to the court earlier suggested that his grades have gone up a little. More recently, since filing the brief, as Ms. Carroll has brought to the court's attention, they've gone up further. But that's my part of my responsibility under Michael B. It's nothing more than that.
Thank you so much.
Thank you.
Moving next to 452, matter of Cal LF. I believe we have 2 of the 3 counsel will be appearing. Both are by video. Ms. Viljoen, good morning. Can you hear me okay?
Yes, I can hear you just fine. Thank you.
And we could probably use at least I could use a little more volume on your end if you can, but Ms. Principal, can you hear me okay?
I can, yes.
We can hear you just fine. You both will see that the appellant has submitted, correct?
Yes.
And I think we'll start with Ms. Viljoen. Anything you'd like to tell us with respect to your argument?
Your Honor, at risk of repeating everything in our brief, we would submit on the brief unless there are any questions.
I don't hear any questions from the panel, so we're going to move to Ms. Principal. Anything you'd like to contribute with respect to oral argument, Counselor?
Good morning. Thank you. I will rest on my brief as well, but I would be happy to provide an update on how the child is doing.
Let's hear the update.
Thank you. So the child is presently 6 years old at this time. He was placed with his maternal grandfather 1 year after he was born. So he's been in that placement for the last 5 years, and therefore he is incredibly bonded to his grandpa, who has been the sole caretaker for most of his life. He's thriving in this placement, and while he suffers from a medical condition called DeGeorge syndrome, Grandpa ensures that all of his medical needs are being met as this child sees several specialty doctors. And Grandpa has him engaged in several services, such as speech therapy and occupational therapy, to assist him with some developmental delays. The child is very happy in this placement, and he has expressed that he would like this to be his forever home. Thank you.
Thank you very much, Counselor. We're all set. Moving next to 453 and 454. 2 of the 3 lawyers have submitted, and it looks like we have the AFC by video. Here we go. Mr. Fox, can you hear me okay, sir?
Yes, Your Honor. Thank you very much.
And we can hear you just fine. You see that the other lawyers have submitted. What would you like to bring to our attention, if anything, during your argument?
May it please the court, I would just like to address the point that's pressed in the reply brief, which is really premised on the contention that the court dispensed with the dispositional hearing in this case. In this case, however, unlike the cases that were cited by the appellate, When the court moved to the dispositional hearing, to the dispositional phase of the proceedings, both the petitioner, Department of Social Services, and the AFC both requested that the court take judicial notice of the testimony it had just heard that morning, probably minutes ago during fact-finding. And the trial counsel for the appellant elected to continue standing mute and did not object to that mode of procedure. And because of that, we think it really isn't correct to say that the court dispensed with the dispositional hearing. The court considered the dispositional issues, the testimony that it had heard very recently that morning. And I would just respectfully refer to the court to the case we cited in our brief, matter of Justina Rose, 28 AD 3rd 659, wherein the Second Department said, and I quote, "The rules requiring a dispositional hearing are not so rigid as to mandate a totally duplicative reprise of testimony presented at fact-finding." In pertinent part, that's what that court said. So unless there are any questions by the court or the court wishes me to update the court on our clients, I would rest on my brief.
Yeah, I'm good.
Counselor, we're all set. Thank you very much.
Thank you, Your Honors.
Moving next to 456, Brian V. Cunningham. Okay, good morning to you. You're Mr. Ryan, correct?
Yes, I am Mr. Ryan.
And I know you're getting ready to give us your argument. Give me 1 second. I want to make sure I got everybody straight here. Mr. Harkala, you represent Ms. Cunningham, correct? Mr. Ryan's the plaintiff. Mr. Lyons, you're here for the town of Manlius? Correct. And Mr. Olson, you're here essentially for the homeowners association of the various individual defendants.
Correct.
Okay, I've got the plate. Mr. Ryan, the floor is all yours, sir. Go ahead.
Thank you, sir. May it please the court, I'd like to reserve 3 minutes for rebuttal.
You may have heard me right at the beginning. Our tradition and our rules, sir, do not permit rebuttal.
Okay. This appeal arises from a case that has grown more complex, not less, since the September 18th order. The order.
Mr. Ryan, do you mind if I interrupt you with some questions right away?
Please,
And
yeah.
if you prefer to make your presentation, I know you're representing yourself.
Yeah.
But I want to make sure you're given your due here.
Okay, sure.
Like everybody else, you've waited for your turn.
Right.
The central issues, if I understand it, as to some of the defendants is whether or not a default judgment should have been granted, and as some of the defendants as to whether or not their affirmative defenses should have been stricken.
Yeah.
That may be a pervasive theme for all of them, I forget.
Yeah.
But so are those generally the issues that we're looking at?
No, the key factor that I'm looking at in this motion, despite those that probably the defense is more interested in those, I'm interested in the restriction on my right to make a motion. I have a motion restriction in this case.
There, the court, there you, I'm sure you realize as a lawyer that you wouldn't even establish that the court abuses discretion in imposing that restriction.
It has to do within the guidelines, and there's a very specific test, and that's
Go right ahead.
is that it's the imposed restriction on future motions that has left appellant without the tools for New York procedure to restrain this case and move it forward. The question before
Are we on discovery now? We were just here about a month
ago, and we're not that much further along because there's still outstanding discovery issues, and I have no motion practice to compel evidence. So this is getting in the way of the orderly progression of the case.
Well, you have ability to make a motion, but you need to get the permission from the court to do so.
Yeah, but I can go into some of the very real problems with that now at this point. And that's a permission bank. It's a restriction dressed up as a permission based. There has been denial of permission. For instance, I always sought to ask the chief enforcement officer of the town of Manlius a motion to amend, under Hart v. Buffalo, a normally relatively low bar to approval, denied. It was denied.
You didn't tell us what it was you were asking for.
It
You said
was
approval to make a motion, but for what?
To add a motion to amend,
Add a defendant.
to add a defendant. As the evidence develops, we learned that there was ministerial duty problems and had to add the chief enforcement officer into the case to bring all the necessary parties.
Suppose that could be a future appeal.
It is
I'm not encouraging it.
Yeah, I'm tired of appeals. And if I had regular motion practice, I can get order to this court.
I think I may be wrong here, but it may be even more, but at this time, you've already filed 20 motions?
There's 24 motions in the case. I filed 18, about 6 or 7 of them related to the individual defendants. These are not frivolous motions. It's voluminous, it's thorough, but it's not vexatious. And a motion restriction has to meet the test in Miller v. Lazaria, I believe it. Let me get the exact name. It's Lanziera, pardon me. And that it goes within, constitutional and statutory restraints. Pre-filing restrictions must hit a 3-part test under that. And the 3-part test is prior warnings, narrow tailoring, and frivolous or abusive conduct. There's no findings of that, and you won't find it because I argue in terms of the law and the facts. I'm not bringing up motions just for my own health, and I'm certainly not doing it to extend this case. I have a fire hazard outside my window. I would like it to be heard on the merits. We're 2 years in, and I don't have a hearing on the merits yet. I'm trying to develop the necessary evidence. And I'm being frustrated because my motion practice to enforce the rules of the court and the CPLRs, the motions to compel, I don't have that.
Do you have a scheduling order and
No, we don't.
you requested that?
I'm still not through getting answers to my documentation. I have, for instance, a privilege log I need some data on. And I can't bring that motion, and I'm waiting for a transcript for 2 months out of a document conference that we had. So this is compounding and compounding and compounding. I need to have motion practice to be able to get these things.
Okay. Mr. Ryan, anything else? We obviously have your brief, you know that. But is there any other issues you want us to focus on?
There is, and the practical consequences is assuming that this argument in fact lands. By the way, yesterday I had a denial at the appellate court and I believe some of you were on that, a denial of my the ability to, because it's a letter order. Judge Antonazzi gets a letter order. It's not a motion to add this.
It's not before us in this appeal, sir.
No, but it's related to the lack of motion. I can't file a motion. It's directly related, and here's how.
Well, I don't think our last decision's been issued either.
I know the last decision.
You argued it hasn't been released.
No, but there was a denial of my 4th appeal, which was to add by letter order. You do not have jurisdiction over the lower court because it was a letter order and not a motion. And that was to add Mr. Poitras to the case. And because it was a letter order,
When you say letter order, you mean that the court said okay?
the court did not say okay.
Okay.
But he said you can't add him to the decision.
Okay, so somebody can do an order.
No, he won't do an order. It was a letter and he did not file, it's not an order, it's a letter.
You're bringing up our decision on that motion
yesterday
that you brought pertaining to the appeal in order to demonstrate your frustrations with respect to the inability to get matters moving forward because the court's not granting the permission for you to make these motions.
Right.
And is not allowing you to make a decision.
And then I can't have it heard at the appellate court. And so your jurisdictional requirements are gone.
Right.
And so the judge has an ability to operate in a blind spot down here without supervision, and that feels fundamentally unfair. Because the initial order to deny, or the initial denial of my ability to make motions was not done by the Miller test, the 3-part test. It's like, hey, there's a lot of motions to stop. You have to do it within the framework. There's discretion, but you can't drive that far off the road. So that's the problem. But I'm asking, if you decide for me, the relief we request includes reassignment to a different justice, not as a criticism of the court, but as a structural necessity for what follows. After the September 18th order, when ex parte communication occurred with an opposing counsel, which is in the 5519 request that I spotted what happens afterwards. I'm not arguing that my ability not to have my motion practice is theoretical. There are real world consequences in this case to get it one moving. I don't want to clog up your docket. I want to get to the evidence, but I need motion practice to make it operate on a timely basis. I need to see the evidence. And right now, evidence is in control. This is someone built a wall on my property. I didn't do anything. They all did it. They have the operative facts about how they did it and how we allocate blame and responsibility for doing this unlawful act of building the wall on my property without fireproofing. I want to have this heard, but I need to get the evidence that they have to properly allocate who is responsible. Is it the contractor? Is it the town? Is it the property manager? It's a dog's breakfast of a fact pattern. I assure you, it's not one I want to argue. I'd like to have something neatly plated here, but it's unruly. I get it. I'm frustrated too. The judge is frustrated. He should be. And you should be frustrated because it's getting all these appeals. I am trying to limit things. And with motion practice, I can limit, get an orderly process, get the CPLRs. I'm pro se. Yes, I have a law degree, but it's been 30 years. I'm not a practicing lawyer, but I do need to get the rules enforced here in an orderly way so that I can get this case moving properly and with efficiency, which I would very much like to do.
Thank you, Mr. Ryan. We'll take a close look at all the issues you raised.
Thank you.
The one you discussed here today.
Thank you.
Next up is Mr. Herkula.
May it please the court, my name is David Mercola. I'm an attorney with the Serial Law Offices. I represent the individual defendant and adjacent property owner in this case, Susan Cunningham.
You heard the argument that the focus today was on the injunction against future motions without permission. That seems to be the focus for today.
I understand, if I could only, Your Honor, only because there is an argument that was made that my client is in default. And I will admit that her answer was 11 days late. Subsequent to which time we have engaged in multiple court conferences. We have provided discovery responses. We have responded
Is
to
the key issue there, Counselor, whether we look at the court's order, I think it's from May, and determine whether it's conditional or not.
That may be an issue for that judge. My submission, obviously, to the court, my brief and my argument here today is it's not a conditional order. It did not set a quid pro quo.
If conditional order, essentially, my recollection from the trial court is if you don't do X, dismissed or granted.
That would be a conditional order if that's what it said. It actually doesn't say that. And just for the court's reference, our answer was by plaintiff's own admission in his possession as of January 7th of last year. And it was on e-filing, is docket number 5 in the e-file system as of February 20th of last year, which constitutes.
This case was not commenced as an e-filing case.
It was not. So,
That might explain a few things.
Which is where a bit of the delay comes in, and frankly, I am happy to take a shame on you, Dave. You should have refiled an answer that was already docketed and in the e-file list. I'm not sure what would have happened. My suspicion is it would have been rejected.
Sorry to interrupt you again, but as I understood your point in your brief, is that the court entered an order compelling the receipt of the answer, that game over.
Game over. Exactly. Yes, Your Honor. With respect to the affirmative defenses, just very briefly, I don't believe we're at a point in the process of this matter where moving to dismiss affirmative defenses is appropriate. We have not completed discovery, which is not to say that we haven't engaged in discovery. We have engaged in substantial discovery. We've had requests for documents. We've had supplementations that have occurred. We had a full party multi-hour conference with the judge to try to address and resolve the discovery issues, in part, in my belief, in an effort by the court to also hopefully resolve the fact that we're looking at 18, 20 motions on a case that didn't even, get in front of the judge until February of last year. I mean, that is a substantial amount of motions. as far as my position on the court's motion, the order to restrict the filing of motions to those that you obtain permission beforehand. My understanding of the court's order and my interpretation of what he has said to us during court appearances on this matter is give me a detailed letter. Tell me why you think you need a motion. If I'm able to resolve this without the cost, expense, and time and waste of effort of everybody, with all these parties having to respond formally from a motion standpoint, I think that's a more prudent and efficient way to handle this. I realize that the appellant does not agree with that approach, but in my opinion, I believe that the Supreme Court's approach to handling what has been a voluminous motion practice in this case is appropriate given the circumstances that we are facing here. And so my position is, with respect to the issue that has been framed by the appellant at today's argument, is that the Supreme Court's order is wholly appropriate in these circumstances.
Don't misunderstand when I say that's the focus of the argument. We're going to look at all the issues.
I understand, but Judge, I do feel I addressed the other two arguments. Thank you.
Thank you, Counsel. Mr. Lyons.
Good morning, Your Honors. May it please the court, Paul Lyons from the Sugarman Law Firm, representing respondent town of Manlius. Of note, the town intends to rely on our paper submissions with two additions. One, last week, the Supreme Court Justice granted the town's motion for summary judgment with respect to the legal issues of special duty and discretionary nature of the code enforcement officer's actions. That has been appealed, I believe last week, the same day as the decision was ordered. And secondly, in the appellant's reply brief to this pending motion, he cites the People versus Carguella case with respect to a prejudice argument, citing that it's a Supreme Court Kings County criminal case with respect to a Brady hearing. So I don't know how that really applies to this matter. With respect to the appellant's arguments regarding the motion injunction, I believe Attorney Hercola really summed it up nicely, and we echo his sentiments. If the court has any other additional questions, I'm happy to answer them.
I think we're all set, Counselor. Thank you.
Thank you, Your Honors.
Mr. Olson.
May it please the court, Gardner Olson, on behalf of defendants, respondents, the homeowners association, and the 5 individuals associated with the association. My argument in my brief was limited to one single issue, and it was Mr. Ryan's underlying motion to strike the affirmative defenses, which was made right after the answers to the amended complaint were filed. And I agree with Mr. Hercola. It's just we're not at a stage in the litigation where that's an appropriate motion. It's premature. With all due respect to Mr. Ryan, he employed the wrong legal standard in his motion. I haven't moved on my affirmative defenses. I don't need to prove them right now. They just need to have legal merit, which they do. He essentially concedes that all of the other affirmative defenses are meritorious because he singles out 3 equitable defenses that were raised. He's making claims for equitable relief. At this point in time, it would be inappropriate to strike the affirmative defenses. So I would respectfully submit that they need to remain at this point in time. And other than that, I'll just rest on the papers.
Thank you, Counselor. We're all set. Moving next to 457 Stash Investments Corporation versus Seelig. And if I'm mispronouncing, please accept my apologies. We're all set, Counselor. Go ahead.
May it please the court. My name is Chad Davenport, and I represent the defendant appellant Lenny Seelig. This appeal presents an extraordinarily rare circumstance where we have both of the principal negotiators testifying unequivocally that the written agreement that the trial court was looking to enforce is not the agreement that they had agreed to during their discussions. We believe that the trial court committed reversible error by elevating the speculation of the drafting attorney.
Mr. Davenport, this case came to my attention late last year, it was decided in December. Are you familiar with the Court of Appeals case called Smith versus City of New York? Came out in December. It's okay for now. It's relatively new.
I am not, Your Honor.
Just so you know, it was a tort case, and so would seemingly not be pertinent, but the ultimate point I think will be. The plaintiff and the city settled one of the two false arrest actions that the plaintiff had brought. And then in that one that they settled, there was a release executed by the plaintiff. And it said that this will include everything that you have vis-a-vis the city unless you exclude it from the release, which neither the plaintiff nor his counsel did. That goes through to enforce the release. And the Court of Appeals unanimously affirmed enforcing the release under those circumstances and rejected the argument of mutual mistake, citing there that Chimart case that I think everybody, Chimart case, CHAIMART, that everybody cites. It says, with respect to mutual mistake, a high order of evidence is required to overcome the heavy presumption that a deliberately prepared and executed written instrument manifests the true intention of the parties. That's the standard that governs this case, correct?
That is correct, Your Honor, is that it requires a very high level of proof.
Did you meet that here?
So we believe that we met it in several different ways, not just the testimony, which has been unequivocal throughout this entire proceeding by both of the principal negotiators, Lenny Siolik and Jim Ziebach. Both of them has testified unequivocally that Mr. Siolik made it very clear during the negotiation process that he would not accept any loan from Stash unless it was secured only by the shares of stock. And then when asked at trial whether or not Mr. Ziebach told Mr. Siolik that the credit line would be secured only by his shares of stock, Mr. Ziebach testified and stated 1,000%. So that's the testimony of the two principal negotiators. But we believe that there's also contemporaneous evidence.
Just so you know, you've seen the opposition's brief, and they lay forth a testimony other than what you cited. You cited to primarily about, I count 10 pages of testimony between those two witnesses. They cite a series of lines of questioning where the parties were asked about, did you discuss this? That is, whether or not this remedy could be allowed. And the answer is repeatedly no. They certainly discussed the idea that the shares would be used to secure, but that in itself doesn't mean that they excluded all other remedies. And the documents seem to say all other remedies are available.
So, and this was set forth in the trial testimony as well. Both of the principal negotiators did not think that they had to have that discussion about what other forms of recourse might be available. Both of them testified unequivocally that they are not lawyers, they are lay people, and they did not know.
Sophisticated parties running very successful businesses, at least at the time, correct?
Yes.
With counsel, correct?
So there is evidence of Stash having counsel representing them and helping them through this loan agreement, but not on Mr. Siolik's side. And in terms of reviewing the specific contract itself, Mr. Siolik said that he was reviewing the contract himself. And both Mr. Siolik and Mr. Ziebach testified that when they reviewed the agreement, the loan agreement, they believed that it reflected what their conversation back and forth was, which was that it would be secured only by the shares of stock, because they kept seeing over and over again the terms referring only to the shares of stock. They did not know the difference between recourse and non-recourse, and that was set forth in the trial testimony. They were asked questions about that, and that was what they testified to. We would also point to the trial testimony that shows that Mr. Ziebach actually had a conversation with Shahid Khan, who was the CEO and chief of Stash Corporation, and presented to him exactly what this loan agreement was supposed to be, which was that this would be secured only by the shares of stock. And the way that Mr. Ziebach had presented that to Shahid Khan was that this was the perfect motivation for Lenny Siolik, that Stash, as being a 51% stakeholder in Mackenzie's Hard Cider, would reap the benefits of Lenny's hard work and advancing the company.
Didn't the lawyer testify, the one that was involved in these negotiations? I thought the lawyer testified that if this was to be non-recourse beyond the shares, that would have raised, and I'm probably paraphrasing testimony, red flags, and that would have gone up the chain. Because non-recourse is, we all know what that means as lawyers, and it's very significant language. And the only language also that you quote, that's not in any of the documents. So, I mean, how do you contradict the documents that your sophisticated client signed?
And what I would point to, Your Honor, is that the testimony that came from the attorney and the drafting attorney in these circumstances, it was based on his speculation, based on other past loan dealings that he had dealt with. He believed that the way that this deal was negotiated and the way that this deal was coming about and what the terms were going to be, he believed that the parties intended for it to be a recourse loan. But he admitted in his trial testimony that he never had the conversation with Mr. Ziebach or Mr. Ciolik about whether or not this was intended to be a non-recourse loan. He admitted that. And we would also point to the fact that there was a very low interest rate that was used. It was a 2% interest rate that was used for this loan agreement, which again points to this being a friendly transaction based on a close business dealing between, a professional relationship of an investor and a small investment startup company to incentivize the main person who is moving and driving this business along to increase the value of their 51% shareholder stake. Because, and I would also point out the fact that when the attorney says that he would have ran it up the chain, the trial testimony from Mr. Ziebach evidences that he already ran this up the chain. He already talked to the chief CEO of Stash Corporation, Shahid Khan himself, and presented exactly what Mr. Ziebach has testified to unequivocally throughout this proceeding about this being a non-recourse loan specifically focused on just the shares of stock. And I would also point to the evidence that was in the trial record as well, that at the time that this deal was made, those shares of stock, Lenny's, Mr. Ciolik's 20% shareholder stake in Stash Corp or in McKenzie's hard cider was worth about $1.2 million. So there was plenty of equity at that time just in the shares of stock. There certainly would not be any concerns from Stash's point of view that they would be able to have sufficient recourse with the shares of stock. And the other evidence that I would point towards, contemporaneous evidence, is the fact that this loan agreement was not filed with the county clerk. There was evidence in the trial about a separate transaction, Edgewood Bakery. And in the Edgewood Bakery matter, Stash Corporation again made an investment in a small startup company, and they intended for this to be a recourse loan where they could look to the personal assets of the small business owner to be able to seek recourse. And in those circumstances, Mr. Ziebach, who was the chief investment officer for Stash Corporation, said that he filed the loan agreement with the county. He also, to make sure that they could, seek recourse through the buildings, through the mortgages.
Sounds like a UCC filing of some sort.
UCC filings. He also went through and he actually checked the personal credit.
UCC filing wouldn't pertain here.
Well, Your Honor, it had Mr. Ziebach.
That's not your main argument. I get that. You're just trying to add into the facts that support your point of view that you met that high standard that I recounted at the beginning. So I don't mean to pin you down too much on that one point, but what else do you have on this appeal for your argument, sir?
Well, I would also point to an email from the attorney, Mr. McGuire, on February 11th of 2014, where he explicitly stated in his email, based on my conversations with Jim Ziebach, I understand that Jim and Lenny have worked out the terms of a loan to Lenny to be secured by a pledge of shares of McKenzie's. And so, again, this is pointing to the fact that even though, the court might look with skepticism upon these two people, that they would have not known the difference between a recourse and a non-recourse loan, it's very clear that the conversations, both with the attorney and the CEO, Shahid Khan himself, were always designed and tailored to and focused specifically on the shares of stock. And they just simply did not know that they needed to have a separate conversation about whether or not it would also pertain to the personal assets of Mr. Seal.
You're arguing that this is an either or situation, and that's not necessarily the case, because a lot of it, it's usually in a real estate deal with a property or an office building or whatever. And the person would borrow the money secured by that piece of real estate, but they're still personally liable unless the document specifically says non-recourse, which banks recently are, not willing to do. And your burden here is clear and convincing. So where is that in the record?
So what we would point to, Your Honor, is the fact that when Stash Corporation gave this loan to Mr. Ciolik, they knew that the purpose of this loan pertained specifically to him being able to finance a home purchase at that time. Had Stash Corporation wanted to look to that asset, had there been a default on the loan, then they would have explicitly included that within the contract. And the fact that they deliberately left that out shows, again, what the true intentions of the parties were at that time. This is an exceedingly, again, rare circumstance where you have both of the principal negotiators stating unequivocally that this is not the agreement that has been enforced by the court is not the agreement that they intended for it to be. And I would also, before my time is up, I would like to point the court to our evidentiary argument as well, that the court had erred in not allowing the parties to present evidence post the deal to be able to show what the course of dealing was. We pointed to two first department decisions. They were Federal Insurance versus American Insurance Co., as well as Gulf Insurance Co. versus Transatlantic Rains Co. These are both first department decisions. They both stand for the proposition that the most persuasive evidence of an agreed attention of the parties is their course of dealing, is their course of conduct.
Mutual mistake cases?
We would say in mutual mistake cases as well, because
No, are those cases you cited to, do they involve mutual mistake issues? I don't remember.
They don't, Your Honor. But at the same time, too, they go to the general contract principle, which is equitable reformation, and to enforce the court's purpose when in a deal is to enforce what the intentions of the parties are. And we would,
despite the language of the contract, which is why you have the mutual mistake case. I think we have your arguments, or anything you want to add just in conclusion?
nothing further, Your Honor.
Okay, thank you very much.
Thank you.
Morning. May it please the court. I'm James O'Connor with Philip Slato on behalf of the respondent, Stash Investments Corporation. And respectfully, this case is not unique or rare. This is a simple case. I think Justice Greenwood's question was very relevant, which is where is it in the record? We've heard this morning that the individuals testified unequivocally that they never intended for this to be a recourse loan. I would submit that that is not in the record. The trial testimony and deposition testimony is actually the exact opposite. There is some testimony that is cited in my opponent's brief, whereby Mr. Ciolik testified that he read the documents and saw the words secured by the shares, and he believed that that meant they could only go after the shares, not his personal assets. That is different than what counsel said, that they agreed that it would be only the shares. That conversation is not in the record. And it's a voluminous record. And in fact, we had to fight to get the whole record before you. Another point I'd like to make about the Edgewood case that counsel referenced, the difference there, not only that it was a different transaction, that case involved two corporate entities entering into the agreement. So obviously there needed to be a personal guarantee. In this instance, Mr. Ciolik was the signatory. There's no need for a personal guarantee when his signature is the guarantee. I think also that Justice Kern's question at the opening is very on point, that this is a high burden, a high order of proof, and we would submit that it was not met, not even close. To reverse, this court would need to find that the lower court abused its discretion in weighing the credibility of witnesses and determining admissibility of evidence. Those are powers that are acutely within the trial court's prerogative and afforded great deference. That is the Monto and McMillan cases, along with the Saraiva case from this court from last year. Justice Green's decision says there was no persuasive testimony. The judge found that the testimony was not persuasive to the extent there was any. So from our perspective, this is actually a very simple case. The words matter. And there's a red herring in the argument that because they're laymen, that they needed to say no recourse, non-recourse. That's not what we argued. That is not what the trial court found. Not once did the court say they needed to say to each other during negotiations, I want this to be a recourse or non-recourse loan. The court did ask
And I asked, as the trial attorney, did you ever discuss the fact that the shares would be the only remedy? Answer consistently was no. The Chimar case, as Your Honor referenced, also requires that the evidence not be loose or contradictory, and that not only must there be a mutual mistake, there must be evidence of what the parties actually agreed on. I believe the term is the exact terms. And there must be a certainty of error here. That's the Ross case. We would submit that it's not even close, and they never even discussed it.
As I read your brief, you're also relying on the general principles that we have with respect to when we review a non-jury verdict.
That's right, Your Honor.
One of which is that the decision of the fact-finding court should not be disturbed upon appeal unless it is obvious that the court's conclusions could not be reached under any fair interpretation of the evidence. And here the court concluded, among other things, that both parties, Zibak and Zielek, and I know I'm mispronouncing, forgive me, testified that while they did discuss a specific collateral securing the loan during the course of negotiations, they did not discuss limiting the remedies available to Stash upon Zielek's default. That's right out of the court's decision. It seems to me for the plaintiff to prevail here, or Zielek, the defendant, not the appellant, to prevail, we would need to find that that was obviously wrong.
That is correct, Your Honor.
Okay.
And we would submit that that is not the case whatsoever. I think what we have here, I think counsel said it during his opening remarks, is that they didn't understand the terms. Even if that were the case, which I would submit that it is not, given that these are sophisticated parties who were represented by counsel. There's a separate issue that Mr. Zielek did have counsel, Joseph Zablotsky, reviewing the loan.
But he was only reviewing the real estate portion, right?
That
he indicated, I'm not dealing with the other part, basically.
That's what he says, yes.
And in any event, I mean, would that be a signal to Mr. Zielek to have someone else who was more versed in that type of law to examine that?
One might think, yes. He did not do that. He did
You're talking about them, you know, Stash was represented by McGuire, right? I mean, he's the one who was doing the work. It was the fact that the Stash representative, Zielek, is that his name?
Zibak.
Zibak, yeah, they didn't understand the terms, doesn't matter, they had an attorney.
That's right. Yep, and it's black letter law. Misunderstanding is not a defense. That's the Pearl Binder case and the Elliott case that we cite in our brief. It's also in pattern jury instructions. So from our perspective, this is a simple case, and it's an easy affirm from our perspective, respectfully. One other point I'd like to make, my final point would be that Appellant has made an argument that the trial court's decision is fundamentally inconsistent with this court's prior decision. I would just respectfully disagree there. This court back in 2019 found that Mr. Zielek had at that time presented enough to raise a triable issue of fact as to whether the mutual mistake occurred. We had that trial. He failed to prove that fact. So I don't think there's any inconsistency. And the last thing I will say that may not come through in our papers is that, you know, the credibility is at issue here. And the lower court consisted at times of 3 separate judges, Justice Nowak, Justice Walker, and now Justice Greenan. And they have all come to the same conclusion. And I would ask that your honors come to the same as well and affirm the lower court's judgment and decision. If any other questions, I will rest on my papers.
Counselor, I think we're all set. Thank you.
Thank you.
458, Lutersky versus Militello Farms, Inc. et al. Yeah, I didn't want to leave out 458 either. So 458, good night. Thank you, Justice Bannister.
Thank you, Judge. Good afternoon, Your Honor.
Good afternoon, Ms. Wheeler. First, good afternoon.
Ann Wheeler, on behalf of the plaintiff appellant respondent, Kevin Lutersky, may it please the court. The Court of Appeals in the case of Runner held that the primary inquiry as to whether Labor Law 240 is violated is whether the plaintiff injuries resulted from the defendant's failure to provide adequate protection for a reasonably.
There's sort of a distinction, Ms. Wheeler, if I'm understanding correctly. The court cited to Roble, right?
Yes.
And you cited to Wild, I think, where we held that contrary to contention of the defendant, plaintiffs fall into an excavation from the ground level is the type of elevation-related risk for which labor law section 240 provides protection.
Yes,
So that's one of the debates here. I assume that's where you were taking us on the 240 sub 1 issue first, given the citation.
I was, Your Honor. I was. So to get to that framework where Wild and Roble disagree, you need to look at the overarching framework that comes down in Runner. We need to look at whether the injuries resulted from a gravity-related risk for which an elevation related safety device could have and should have been provided.
Your client testified, among other things, if I recall correctly, that in this muddy excavation hole, he saw what appeared to be the prints of a bulldozer, whatever that scraped out the earth.
That's correct. It was
I'm not using the right words, but
yes, he saw the teeth of the excavator engraved, so to speak, in the sides of the trench in which he fell, which was 4 feet by 4 feet by dimension in width and length, and it was approximately 3 to 4 feet deep.
there doesn't seem to be much of a factual dispute as to what that hole was. I mean, I think there's a big dispute as to who did it, perhaps, or when it was done. But I'm not sure about that.
I think,
Go ahead.
yeah, there's a dispute about who did it and when it was done, articulated in the arguments. I think in the proof in this record, there's no indication that anyone other than Rousseau Development, the defendant in this case, defendant contractor, was digging at this site.
Is there any evidence in this record that Militello even knew that this was going on that night?
There is no evidence in the record that Militello knew that the work was happening that night. That is correct.
And there's any evidence that Militello made this excavation through some equipment of its own?
There is no evidence that Militello made the excavation. No, Your Honor. The only indication in this record is that Rousseau made the excavation. Rousseau was the only entity that's been identified in the record in this case as an entity that was digging excavations at the site.
And again, everybody's waited here to have their time, but it looks to me on this 240 sub 1 issue that we've got to look at those cases that both parties are citing and see which of those cases does this fit into?
Yes, Your Honor. I think the inquiry comes down to whether or not a safety device was necessary or expected. And that goes back to
if this is an excavated hole, it shouldn't have been left there unprotected.
that's the undisputed testimony in this case, Your Honor. Yes, by two Rousseau representatives testified that if they dug an excavation and for any reason they were not actively working on it and it became it became abandoned or they left the site, that the trench had to be protected by barriers or covering or things of the like. So there is no dispute that in the circumstances testified to by the plaintiff, which that there was not active excavation work being done at the time, this trench that was dug by an excavator, according to my client's testimony, should have been covered.
So after the 240 sub 1 issue, where are you going to take us next?
Well, I think that if the court agrees that 240 is applicable in this case.
I didn't say that. I just said,
assuming that the court were to get to that point, we would also argue that the plaintiff is entitled to summary judgment on the 240 cause of action. The primary, I think there's two disputes.
You don't see a lot of questions of fact here, Ms. Wheeler, about how this went down, the text messages, how it stacks up, the timeframes. I think Russo produced the work order or some document like that, setting forth some times. They testified about that. Doesn't that timeline and who did what kind of create a question of fact as to whether or not the statute was violated?
I believe that the timeline is quite murky, Your Honor. Though I do think that based on the proof in this record, there's no indication that any, as I stated before, any other entity would have dug this trench besides Rousseau Development. And if you pair that with my client's testimony describing the hole, which is unrebutted, if this was in fact dug by an excavator, then Rousseau would have been at the site. Rousseau would have assumed their duty to provide the protections required by the labor law, and they failed to do that by providing guarding around the hole.
What's next, if anything?
I think that the court below properly determined that with respect to the 241-6 cause of action, that the 1.7b regarding fall hazards, hazardous openings, is applicable to this case. And then with respect to the 200 cause of action, I think if there is a question of fact as to who dug the hole, as your honor was alluding to earlier, then there is necessarily a question of fact as to whether Militello had notice. If we're going to agree with the principle that there's a question of fact as to when in time this hole was dug, if it was not dug that night, it must have been dug at some time prior to that night. The property owner was had his obligations under Labor Law 200, under the common law, to inspect his property, to reasonably do so, and ensure that there were no unsafe conditions there.
For my benefit, take me to your argument, if any, on 23-1.7D, I think it is. That is the foreign substance issue on that regulation.
Yeah, so in our client's,
It's not foreign substance here, right? It's all mud.
it's mud. Rain is a specific water, ice, other foreign substances are expressly prohibited by the code rule. So I would think that I would state that there is a slipping hazard there. My client's testimony is that he stepped into the hole. I know that in the
What's the foreign substance?
water.
What is it?
Water, which is water is one of the substances.
I thought your argument was that it was mud.
Well, mud is water and dirt together, Your Honor.
Okay, thank you.
I think in the water is the rain.
The water.
Falls natural.
Water is the
We're gonna find rain in foreign substance.
I think there's a water main break here too that we're dealing with. But my client's testimony is that he stepped into the hole at his deposition. I know that there's other unsworn documents which counsel got into in their brief with respect to maybe stating to medical providers that he slipped. I think that the sworn testimony in this case that he stepped into the hole.
Okay.
The end of our hole.
Thank you very much.
Thank you, Your Honor.
Mr. Mills, you represent the landowner, Militello. Do I have that right?
I do, Your Honor. Thank you.
Go right ahead, sir.
Yes. So we submit no questions of fact here whatsoever as to who dug the hole. We did not create the defect. We did not supervise it. We did not.
You don't need
control
to
it.
prove that Russo dug it. You just need to show that you didn't know anything about it. You didn't do it.
Correct.
Okay.
You know, which we think the record is clear here. There's absolutely no evidence that we even knew this was going on at the time.
So you couldn't control the work. You couldn't do it. You didn't dig it. So, okay, what else?
That's essentially it, Your Honor. You know, we didn't have, there wasn't any evidence that we knew this was going on. This was also at the edge of our property in an easement area. And we submit that the underlying court got it right.
Okay, thank you.
Thank you.
Good afternoon. May it please the court, Kevin Krupa for Russo Development. I want to touch first on the Wild case that Justice Curran raised. So the Wild case involved, it's a 2010 case from this court, in which this court held that 240 applied where plaintiff's foot slipped off when he stepped onto a plank that was partially covering the excavation. If you look at this court's decision in the Pitts case, I think this court very well explains the distinction between stepping into a hole and having a safety device that's covering a hole fail. And I'm going to quote the court, the citation for the Pitts case.
Well, it doesn't just have to be, and don't lose your train of thought, because I know you're going to tell us about this case, but it doesn't just have to be the failure of a safety device. It also has to be the failure to provide one, such as taping, warning, whatever around this excavated hole, I think is the argument for the plaintiff. So I wouldn't just focus on the failure of a sale, that it didn't work.
Okay.
But I think the argument is, if I understand correctly, it wasn't provided.
Well, Judge, in this case situation, and we go back to kind of the second point that you raised with Ms. Wheeler, there's a question if this excavation was even there when Mr. Latursky was at this job site.
But that doesn't mean the statute doesn't apply, to use the double negative.
I think it does, because Mr. Latursky claims that he fell in some hole that he doesn't know who dug. Well, he thinks it's Russo Development, but that's who he's pointing the finger at. But we don't know what hole he claims he fell in. Russo Development wasn't there when the plaintiff was there. The timelines, as you noted, Justice Curran, don't match up. So that's a question of fact. Now, we don't know what this condition was.
That gets you denial of 240 sub 1, but it doesn't give, as I understand, it doesn't get you to the inapplicability of 240 sub 1 in terms of the contention that it was your client who excavated the site and failed to provide safety devices.
Well, I think it does, Judge, because the testimony from the Russo Development attorney, or well, the Russo Development workers were that they never left the site and they guarded that hole the entire time that they dug. So I see where you're going with respect to, you know, under the Pitts case, you know, is it a failure or do they have to provide it? But here, I think you have a hole that we don't know where it came from, who dug it, what, even if it existed. And the claim is that he fell into an excavation from the side. And under the Roble case, which is decided in 2014, and the Pitts case, 240(1) doesn't apply.
Okay, what's next?
What's next is I want to go talk about the various questions of fact that you pointed out to plaintiff's counsel during her argument. So we've got first the text message to Mr. Walsh, where he says, I dropped my equipment in the water, but I didn't fall in the hole.
How this happened and when it happened would be your argument? Am I close?
Well, I think it's more
questions of fact.
The questions of fact. The questions of fact are, was there a hole even there? Because the plaintiff offers various versions of this accident, immediately afterwards. So first he tells his coworker that he drops his equipment in some water, but he doesn't fall into the hole.
So we couldn't decide any of that as a matter of law, is your point?
Exactly.
So you can't win on that either.
Well, that's a question of fact, Judge. That's requires a denial of their motion. Yeah. And then he tells his supervisor, Bryce Johnson, that he slipped in the mud and fell and hurt his back. No excavation mentioned at that point, no hole mentioned at that point. He tells the staff at the emergency room at Brooks Memorial Hospital, they slipped and fell on his right side. Again, no mention of any excavation, which is a very important point if that's the crux of the case, Your Honor. He also completes a handwritten form for his neurosurgeon, Dr. Denhays, where he says, I fell on my right side and hurt my back. Again, no mention of any type of excavation.
Well, I wasn't going to interrupt you, but this is the second time you've mentioned something I feel was prejudicial and wholly improper for you to talk about, which is what's in a hospital record that is hearsay. But why don't you go on?
It's an admission.
Don't talk about, well, he's not here to testify about it. You didn't call somebody from the hospital. We can argue about this, but I'd rather you not talk about those kind of things.
Well, we could leave the hospital record out, but we could leave the admissions to his coworkers.
And that's fine, but that's not what we were talking about.
Exactly.
Yes, no, that's okay.
Exactly.
So the issue for trial is whether or not pertains to diagnosis and treatment. That's the whole issue. But what else do you have, sir?
The other thing I want to raise is that the timelines here don't match up. So plaintiff wants to take the best version of what happened that night and say, well, no, I don't know who was there, but Russo Development must have dug that hole. Then they must have left the site.
It's a fair inference, isn't it, Mr. Cooper?
Well, it's a question of fact, Judge, because the Russo Development
well done. Okay.
Employees both testified that they got on the job site at 10:30 p.m., stayed at that job site until 6 a.m., and never left that hole. So there's no reason to guard it. That's a question of fact that requires a denial of their motion on 240.
What about the question I asked of Ms. Wheeler with respect to that subsection D, the foreign substance?
I think subsection D should be out under 241(6).
I know you think that, but what about the argument here that the water is the foreign substance upon which the plaintiff slipped and you had an obligation to guard against that if you were the excavator?
Well, Judge, this is not the type of area that subsection D pertains to. This is an open, unpaved, grassy field, which has been held 23-1.7D doesn't apply to. This is not a floor, it's not a passageway, it's not a walkway, it's not a scaffold, platform, or other elevated working surface. This is the ground. He's walking around in mud.
Fair enough. Would you say, though, that given the questions of fact, if a jury were to conclude that your client was the excavator, that 23-1.7B and the subsections under that would at least be applicable?
You said B, or make sure.
Yeah, and there's a bunch of like B1, 2, etc. I don't know if I wrote them down. But it's that it's 27B has to do with protection and construction, demolition, and excavation operations. I'm just reading from the PJI sections on the regulations. But my point is, and if you want to disagree, I'd like to hear it, that if a jury finds that you're an excavator, that you excavated this hole, then those regulations would be applicable to that excavated hole, correct or no?
Well, Judge, I don't think a jury will find that they.
I'm not saying they're violated, but are they applicable?
I don't think so, Judge, because here the testimony was that they never left that hole. They never left it unguarded. So if the jury finds that they excavated the hole, I think they would also find that they didn't leave that hole unguarded. But also the argument I raised in my papers was that, requiring Russo Development to inspect this job site so plaintiff can then inspect the job site so Russo Development can do his work is inconsistent with the work that Russo Development was performed. They couldn't do their work until plaintiff did his work.
Understood. Thank you, Counselor.
Thank you, Judge.
Did you have a question?
I should say, what about the fact that if there's an emergency, though, they would be able to do that without having the plaintiff do his inspection?
Well, No, they couldn't.
Was the
because-
water line main an emergency?
Because it was emergency, but they have to wait for him to mark the utilities before they can do their work, and the Russo development testimony was consistent about that.
Go ahead. All right.
You know, also, Corey,
I think we're all set. Thank you, Council.
Thank you.
Thank you. Calling next 460, the Ideal U Weight Loss Center versus Zelu. Justice Bamlett is recused. Mr. Lennon, Mr. Munir, good afternoon. Mr. Lennon, we're all set, sir.
Good afternoon, Your Honor. Thank you. May it please the court, J. Michael Lennon, on behalf of the plaintiff appellant. So a couple appeals before this one, Your Honor, you referenced the standard for a non-jury trial. That's what we're here on, from a decision and order that came out of a non-jury trial. And what's at issue here are my client, the plaintiff's 3 causes of action. They all relate to the business names of these two weight loss businesses. My client, the Ideal U Weight Loss Center, and the defendant, which started out as Ideal Weight Loss of Buffalo until an injunction was issued in this case. And that's a key fact. As I know this court is aware, we've got a large record here. We have 5 days of proof. We had, multiple witnesses, a significant number of exhibits. But there's a key that the time period that's at issue is a relatively brief period of time where my client believes and experienced and testified to, and we believe we've established evidence of, confusion amongst consumers related to these 2 businesses. And when Judge Nowak made his decision, granted a preliminary injunction, and forced the defendant to change their name, that completely changed the landscape with respect to that confusion. It ceased. That was the testimony at trial. And it's also another key fact that's important to note is that, yes, Ideal Protein is a international outfit, and they do have.
The Ideal Protein had to approve that initial name in the first place, as far as their.
The testimony with respect to the names was that you offer your name to Ideal Protein, and they say, okay, that's all right with us. So it's an approval, but their primary concern, the evidence and the testimony, the primary concern was that you couldn't use Ideal and Protein together in your name. And neither of these parties did. So that was the primary concern from Ideal Protein standpoint. But the key is that whether or not Ideal Protein approves the name, that doesn't mean that my client, in the 3 years before the defendant started operating, that she couldn't have developed a name that was distinctive and therefore protectable within Western New York. And she did. The testimony was clear that for 3 years, at least prior to, she was exclusively known as the Ideal U Weight Loss Center. And that name was synonymous with the Ideal Protein diet. So this goes mostly to the 3rd cause of action, which is whether or not there was a protectable interest under the dilution. And we believe that there was. You look at the case that the trial court cites, the Little India case, and you look at the facts there. Little India, an injunction was granted by the trial court, and the appellate court said, oh, time out. No injunction here. They've had that name for less than a year. That's not what we're dealing with here. The injunction was granted, and what the evidence shows is that the preliminary injunction in this case was effective. Judge Nowak made the right decision, and it wasn't appealed. So in terms of the 3rd cause of action, we believe that there was protectability, and at a minimum, that preliminary injunction should have been made a permanent injunction by the trial court. With respect to the other 2 causes of action, the issue is really the same. It relates to the confusion. We believe that the testimony and the evidence supports a finding that there was confusion during the time where there were these similar names. The question then, at least with respect to the general business law, it moves on from, we have our consumer-oriented conduct. We all agree on that. The court found that. Was it materially misleading? We believe the proof of the confusion establishes that it was materially misleading. And then the 3rd prong there was the public harmed by this?
And the trial court found that there was no evidence of public harm or not sufficient evidence. But the only way they could have found that is if they accept the defendant respondent's position that every ideal protein clinic is the same. And that's not true. These are not franchises. Even defendant was adamant about that. It comes across in the record. They are not the same. And we cited a number of very specific ways that the Ideal You Weight Loss Center, in the execution of the ideal protein method, offers something different than what the defendants respondents, and I would say better. The analogy that we use is the difference, a hotel, right? If you think you're going to stay at the Ritz-Carlton and you end up at a Holiday Inn, you've been harmed. It's a different weight loss experience. So at the end of the day, we believe that when this court looks at the entirety of the record and weighs the totality of the proof and the testimony, that my client did establish its burden and that these three causes of action there should have been judgment in my client's favor, at a minimum, making that preliminary injunction a permanent injunction. Your Honor, you look like you have a question.
What is the specific proof in the record that your client was damaged by this confusion? The court specifically said it was insufficient. So what wasn't insufficient?
So with respect to that I think falls under the first cause of action. So with respect to the issue of damages, there were essentially two things that we focused on at trial. There was the testimony from our expert regarding the lost dieters, and there was the number that came up was 55 when we compared the client lists from the two parties during the time frame. And so what the expert testified to was that the loss of those 55 people related to a certain dollar amount. The part that I'd like to focus on here relates to the advertising costs, because my client in 2016 and 2017, her advertising costs tripled. The testimony was that the reason for the increase in advertising was to combat the confusion related to the similar names of the businesses. Even defendant's expert agreed that
weren't there other businesses, ideal protein businesses throughout?
Yes, absolutely. There were, and there was no confusion related to those. And I think that goes to what I was discussing earlier, Your Honor.
Your client's advertising was limited only to that particular, to the defendant here, not to these other locations throughout.
There was never any confusion.
There was no benefit that you would receive from this by taking or?
Certainly there's a benefit to my client from the advertising, and the advertising would have continued at the same level as previous. It was the increase in the advertising costs that we believe is an appropriate measure of damages. And I understand that the suggestion is that generally in an unfair competition case, if there's going to be damages, it should be lost profits. But I think when you take a look at what the Court of Appeals had to say in Brooks, it's a little bit broader than that, and that it's should correspond to plaintiff's losses that were a proximate result of the defendant's behavior. And it's our position, and we believe that the proof shows that there was an increase in advertising,
which would have increased profits, presumably. I mean, that's the complication of asking for the advertising costs, is that it's done so then without regard to profit. And you may have made a profit on that. So once you get off of the loss of profits, Mr. Leonard, is where I'm concerned. It takes you down a path that I don't think there's proof of. So if you just look for the reimbursement of the advertising costs, is that what you're saying?
That's, in terms of the appeal, that's where we're focusing on the error. Was that
without regard for any benefit that your client received from the increased advertising?
Well, the benefit for advertising, I think, is consistent for any business. You advertise for
then why spend more?
To combat the specific confusion that was created by defendants' strikingly similar name. Which again, I think it just, again, a key fact is that, and that confusion ceased when the name changed.
Thank you.
Thank you, Your Honor.
Mr. Muneer.
May it please the court. John Muneer on behalf of the respondents in this case today. Your Honor previously referred to the standard on appeal, and the standard on appeal after a non-jury trial has been laid out by this court since 2021, there was Reams versus State. It's expressly stated that this court must give due deference to the court's evaluation of the credibility of the witnesses and the quality of the proof. And that review must be in the light most favorable to sustain the judgment. The trial court judge was in a unique position to evaluate 11 witnesses, 5 days of proof, to evaluate that credibility and weigh the 76 pieces of evidence that were submitted therein. And the lower court rendered a decision that found that the plaintiff failed to prove their claims. The proof was insufficient, and the court based that decision on evaluating the credibility of the witnesses. So
How did the court do that? Point to something in the court's decision that did that.
So, Your Honor, in the brief that was submitted to the court, we go through each of the witnesses' testimony. And the lower court did that as well, specifically referring to the only credible witness and went through that testimony broadly, but nevertheless did. And in rendering the confusion aspect under unfair competition, the court really looked into the evidence that was presented. And the court referred to the fact that these are ideal protein clinics. Ideal protein sets the terms that each clinic must comply with. One of the things the court cites to is the actual agreement, the ideal protein clinic agreement. Each clinic was required to exclusively sell and exclusively promote ideal protein products. They also must exclusively employ the ideal protein weight loss method. And although, and admittedly, they're not franchises, Ideal Protein has exerted an extraordinary amount of control on all of their clinics and their network. And the idea is because when a client or dieter walks in to an Ideal Protein clinic, Ideal Protein wants that client to know that you are walking into one of the clinics in our network. We are worldwide. We are renowned. We are famous. We have a great reputation. And that's the control they've exerted. The testimony that came out at trial was just that. Not only does Ideal Protein require their clinics to sell and promote the product, but they direct their clinics to use their advertising materials. They allow their clinic to use their trademark, the name Ideal, and in fact, they promote it. The appellant's own expert testified that he's helped develop over 150 Ideal Protein clinics. Almost every one of them uses the word ideal. Ideal permits its clinics to use that even though it's a trademarked word. Almost every one of those clinics, and this is from the plaintiff's own expert, almost every one of those clinics uses the word weight loss because the very nature of the business that they're dealing with is weight loss. So this is the control that Ideal Protein exerts. Not only advertising materials, but they also require the clinics to produce or to only purchase products from Ideal Protein. You have to use.
Why don't you address the confusion or lack of confusion that existed here? Because that's an element that the plaintiff was required to prove. It seems like there were witnesses that went in to the defendants, your client's establishment, and said, "Hey, where's so and so? You know, it's her business, isn't it? Why are you here?"
Yes, Your Honor. So there were two witnesses that the appellants produced, and these witnesses were at one point in time clients or dieters of the appellant. After the alleged confusion period of 2017, that's really the period we're dealing with. End of 2016 through November of 2017. That's the period that the trial court was limited to in terms of alleged confusion. In 2019, the two witnesses testified that they went into Ms. Zilio's, my client's business, and noticed that she was there. They knew prior, because back in 2016 or 2015, when Ms. Zilio worked for the appellant
there, I think they thought that, oh, did she open another business? She opened another one, right?
That's exactly
right?
That's exactly correct. So not only did they see the food, because all the food's the same, they see all the food on the walls, but they immediately recognized the former coach. So the testimony revealed these individuals requested Ms. Zilio. She was, and she lost her weight working for the appellant. She utilized this diet. She became a believer, and then she loved coaching. So then she started coaching and employing this method and developed a coach-dieter relationship, not only with the hundreds of people that she saw working at the appellant's clinic, but specifically the two witnesses that walked into Ms. Zillio's business in 2019, again, after the alleged confusion period, and immediately upon recognizing her, oh, you're here, we're glad to see you, we like you. But Ms. Zillio shuts it down and says, I am no longer a part of the appellant. And that says everything, because she's not trying to confuse anybody. She's not trying to piggyback off of anybody's good name. She's just trying to operate her business. And to briefly touch on the advertising and trying to combat alleged confusion, well, the plaintiff's own expert testified, and in his lifetime pro forma dieter analysis, which I attack in the brief, but 2016 was the period, was the end of 2016 and through 2017 was the alleged confusion. The appellant's referral rate increases at 208% into 2016. It increases another 100% beyond the 200. So you're at 279, 280% in the period of alleged confusion. It's a staggering number, and the expert, the appellant's own expert, testified to that. And then he testifies to an alleged drop-off in 2019. And that alleged drop-off, he doesn't say that it was a result of confusion. What he says is it's a natural ebb and flow in the weight loss business. New things come out. There's Ozempic now. It's just a new fad. It's an ebb and flow. And that's what he testified to. So, and let alone, not only was this increasing from 208% to the upper 200 percentages in terms of referrals, the appellant's most profitable years, by the way, were 2016 and 2017. And those numbers were set forth in brief, but just from my recollection, 2016's gross earnings were in the range of $3.6 or $5 million, with the most net profit of that year compared to the other prior years. And then in 2017, in the period of alleged confusion, the appellant made the most amount of money she's ever made. She grossed over $5 million with the highest net profit she had. And that's a direct result of, and the benefit she received is Justice Montour pointed out, the benefit she received from that advertising influx of cash. She advertised and she hired an advertising company and put in a lot of money. And that's a direct result of that and a benefit. Furthermore, she opened 2 more clinics during these time periods that was noted in the judge's decision. So that was another piece of the evidence that the judge pointed out, the lower court pointed out, that she's opening one in 2017 during this period of alleged confusion and opened another one in 2018. She's thriving during this time. The only confusion that was testified to, and the court noted this out, was in the appellant's own head. And that was what clearly came out during the trial. It wasn't the witnesses, and there were no damages that could ever be proven from any of this.
So we should apply the deferential standard and affirm is your argument.
Very well, Judge. Yes, that's what I would respectfully request, that the court affirm the lower court's decision in its entirety. Thank you.
Thank you, Counsel. Yeah. Moving next to 461, Torillo versus Cherney. Mr. Schoonmaker, Mr. Gillette. Good afternoon.
Good afternoon. Yeah. Almost said morning. Good afternoon, Your Honors. May it please the court. Corey Schoonmaker on behalf of Dr. Cherney, Dr. DeFino, and HOA. The scope of what was initially raised in our appellant brief has been reduced somewhat by the content of the respondent's brief, so I'll limit this argument to what remains at issue. The Supreme Court erred in denying summary judgment to Dr. Cherney and HOA because the expert affirmations offered in opposition were speculative and conclusory on both standard of care and proximate cause. Now, underlying both of those prongs is an assumption made by plaintiff's experts that there was a pulmonary hemorrhage.
Let's focus on that, Mr. Schoonmaker. For my benefit, just assume for the sake of argument for now that your client carried the burden with respect to the motion for summary judgment. All right.
Yes, Your Honor.
Just for now. The way I'm looking at this record is I'm not so sure that the experts, the plaintiff's expert and your expert, agree on what the standard of care requires. My question to you is, do you believe that the experts agree on what the standard of care under these circumstances required, or did they disagree?
I think there is a disagreement, but the disagreement is born from a misunderstanding or misapplication of what was presented by this patient. So plaintiff's experts are opining that more should have been done because of this patient's pre-existing conditions. And they are disagreeing that the normal thresholds of 10,000 and 50,000 for the various acts are applicable. Now, some of this is confounded by the fact that during summary judgment stage, we were including arguments about whether she had appropriate platelets to go into surgery, and that applied to Dr. DeFino's care. Our motion was granted with respect to Dr. DeFino, and the appeal from that section of the order was not perfected. So to some extent, there's content in these affirmations about the 50,000 threshold that was applied to him that no longer really applies.
So how do we, looking at this record, make a decision are we required to look at this record, make a decision as to which expert is correct in terms of what the standard of care required under these circumstances? And if that's what we have to decide, how do we do that?
I don't think that the court needs to determine which expert is correct on with respect to the standard of care, because if you review the plaintiff's expert, their entire premise is that the standard of care required that further infusions occur, blood transfusions, excuse me.
And here's what I have written down along those lines. The standard of care according to the plaintiff's expert, and I'm paraphrasing it best, is that if the platelets went below 50,000, due to her thrombocytopenia and suspicious bleeding, there should have been an order for a transfusion. That's one thing. And with bleeding present, therefore, there should be an oral transfusion. That your client didn't recognize the possible effects of the transfusion that was administered and therefore should have done a second. Am I on the right target in terms of what the issue is here in terms of, how do we disregard that testimony by the expert?
Because there was no bleeding, Your Honor. Two of the sentences you just quoted depend on the existence of bleeding. There was no evidence of bleeding. It has been honed to pulmonary hemorrhage specifically on appeal, but just generally bleeding, I think, is also something that was at issue. But there was no evidence of any bleeding prior to August 6th, which was after Dr. Cherney had met with plaintiff the decedent for the last
That was the date of death, right?
Correct. Yes, there was, and on appeal, plaintiff relies very heavily on Dr. Fetterman's August 6th note that doesn't diagnose a pulmonary hemorrhage. He's never been diagnosed officially with a pulmonary hemorrhage. It suggests the possibility of a pulmonary hemorrhage, but
we would have to conclude as a matter of law that there was no bleeding for you to succeed, correct? If there's a question of fact as to whether there's bleeding, you lose, correct?
Well, not necessarily, Your Honor, but with respect to the question of whether there was in fact bleeding, however, it should be.
You said there's no evidence of any bleeding in this record, but if we look at the record and find there's a question of fact that there was bleeding, then that would support the foundation for the plaintiff's expert's opinion, would it not?
Only if there is evidence, and we submit there is not, but only if there's evidence of bleeding prior to Dr. Cherney's last date of treatment. I think that's important here because one of the things plaintiff emphasizes is that note by Dr. Fetterman. He describes the possibility of a pulmonary hemorrhage as a new event on the 6th. It's based on observations made on the 6th of blood in the breathing tube, which weren't present on the 5th. Dr. Cherney checked for blood in the breathing tube and it wasn't present on the 5th.
Right, but there were also specific symptoms that were consistent with a diagnosis of pulmonary hemorrhage before that.
I would like to, yes, I would.
That are cited in the affidavit and plaintiff's expert's affidavit.
Plaintiff's expert, oh, sorry.
No, I'm finished. Go ahead.
Plaintiff's expert was wrong about the records, actually, with respect to those opinions.
But going to, and the justice presiding's point, aren't you asking us to make a factual determination? You essentially want us to disregard because they made a factual error, the plaintiff's expert. If we're to finding your argument.
Well, Your Honor, I'm asking the court to find that the opinions derived from facts that don't exist are speculative and conclusory, inconsistent with the case law on those issues.
Right, that you want us to disregard their affidavit, basically.
I would encourage the court to disregard any opinions that aren't based on any evidence, Your Honor. Yes,
That's what makes it speculative conclusory. It was not based on a proper foundation.
Correct, and not only was it not based on the proper foundation, but it's purportedly based on things that aren't borne out by the actual facts. So, for example, there are allegations that the decedent's hemoglobin and hematocrit were decreasing consistently over the course, and that this fall was evidence of bleeding. But if you actually look at the hemoglobin and hematocrit readings, I guess you call them results, they are not steadily decreasing, they're fluctuating, they're going up and down over the course of her stay, and they're relatively stable. I can go through them if you like, but they're highlighted in our papers. With respect to, quote, worsening x-rays, that the experts mention worsening x-rays, but don't actually say what was worsening about the x-rays. They don't highlight any findings in any x-rays. There is an x-ray on the 6th that was a basis for Dr. Fetterman's note that there's a possibility of pulmonary hemorrhage. I suspect that is probably what they're referring to by worsening x-ray, is that one. But that was again after Dr. Cherney had the last day he had treated the plaintiff, and so it didn't affect any of his treatment decisions. There were multiple pulmonologists who examined and treated the decedent, all of whom concluded there was no bleeding, no pulmonary hemorrhage for the days of her treatment, and they've been let out of this case. The ultimate fact, however, remains, and this is important for standard of care, is that on the last appointment, the last examination that Dr. Cherney performed on the decedent, his recommendation was, if her platelets continue to decrease, give her another transfusion. That was the last directive he gave, and that was the directive that she was under at the time of her death. If more transfusions were not done by the treatment team, that is not the responsibility of a consulting hematologist whose position doesn't allow him to just come in and dictate what care should be when there's a multidisciplinary treatment team in the ICU. With respect to proximate cause, I want to emphasize that the decedent died of ARDS, acute respiratory distress syndrome. That is a pulmonary condition. It is not a hematological condition. We have a language from the Supreme Court that, with respect to Dr. Fino, that the decedent's death was unrelated to her long extant hematological condition. That also applies to Dr. Cherney. This was a respiratory-related death. Her lungs were damaged because she aspirated vomit, and her lungs never recovered. To suggest that her lungs would have recovered on their own had she just been given more blood is pure speculation. It doesn't matter how much blood you have if it's not getting oxygen from your lungs. It's also important to note that the treatment for ARDS specifically is breathing support, nutritional support, because you can't provide it for yourself, and then determining the underlying condition to resolve whatever the ARDS is called by, if it can be resolved. It's a high mortality condition. What happened here is her lungs were damaged. She was on breathing support, and then on the 6th, her family determined to terminate that breathing support. We will never know if she could have recovered from ARDS because
that was
breathing
the recommendation of the nurse to go on palliative care, correct?
I would say the determination as to whether to go to palliative care ultimately relies on the family. I know there was a nurse involved. There was the testimony was a little unclear about how that decision came about, but the decision did come about, and so there's no way to.
You know that on this appeal and in the motion, the court has to, essentially presume the facts as supported by the record as true in the plaintiff's favor.
Yes, Your Honor.
So can we conclude that did your client, Dr. Cherney, ever rule out a pulmonary hemorrhage?
The records are silent as to that issue,
So
but he knows.
No, because the most defense counsel will tell me if it's not in the record, it didn't happen. So if he didn't rule that out, and the plaintiff's expert says you should, given the platelet count dropping below 50,000, that the doctor had an obligation to do that. I thought your expert says that's not the standard of care. Their expert says that's what it is, and that's what you should have done. How is that not a question of fact? I keep coming back to this, Mr. Schoolmaker, but it's a challenging case to understand the facts.
Yes, Your Honor.
It's almost like the plaintiff's argument, one thing leads to another. If you have this condition, it's going to exacerbate the ARDS.
I think that in a nutshell, the key comes down to that last appointment on August 5th and the recommendations that came out of it. Regardless of, and this is primarily proximate cause argument, but regardless of prior to that, whether there should have been transfusions at, I think it was 73 right after the surgery, and then there was 49, and it was 73 before the surgery, 49 after, then 11 back up to 38. At any of those points in time, and by the way, he did recommend, and there was a transfusion when she was at 11 that got her to 38.
From which she benefited.
She did briefly, and then it would drop precipitously back to 19.
So why not do a second?
There is a very good reason not to do a second immediately, unless you have confirmed, as he did. He said that you should, if they continue to trend downward, do a transfusion. If they're stable, he wasn't recommending one at the time, if they were stable at 19. And there are two really undisputed medical facts that go into this. The first one is spontaneous bleeding starts at 10,000. So if you're worried about spontaneous bleeding, where people are just bleeding out of everywhere because there's nothing to keep the blood congealed, that's at 10,000. And that giving too many transfusions causes transfusion resistance, particularly in people with hematological conditions. And so you can't just give them willy-nilly. It has to be a determination balanced by the risk of over transfusing the patient. And so at that point in time, the previous one reducing, I think, from 38 to 19, he then, upon seeing that, said that there was, he recognized that there was a benefit from it. He says that in his note. And then he says, but if it continues to drop, give her another transfusion. That was the instruction that she was under when she passed away.
Mr. Schumacher, I know we've had a lot of questions for you, but at this point, I'm going to ask you to kind of wrap up if you can.
Absolutely, Your Honor. The only other thing that I want to point out is the respect to HOA, that the motion should have been granted, should definitely have been granted with respect to vicarious liability for Dr. DeFino. Yeah, yes. And then also we would then maintain
that might be my first question for your colleague here.
And then obviously also we think it should be dismissed with respect to Dr. Cherney for all of these reasons. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Josh Gillette. I'm here on behalf of Josephine Trillo's estate. I can go into arguments or
I'm looking
based
for
on the questions, I'm guessing.
question. I mean, the fact that Dr. DeFino is out of the case, any vicarious liability of the group should also go away, correct, so to speak?
Well, I think that they're still vicariously liable for Dr. Cherney. So
understood. But
yeah, to the extent that
DeFino, there's kind of this loose end that I see explored in the brief.
Agreed completely, and I think we put in our brief, yes.
Don't necessarily write it that you did it by consent, but that didn't seem like your strongest issue. If I
no, there won't be any claims against Dr. DeFino at trial, so there shouldn't
have
be
against
correct
as a result.
Yes, 100%.
You've heard the questions from the panel,
and I agree with.
Appreciate we're as thoroughly familiar with the record as we can be, given the other cases.
Yes.
But you've waited this long to be heard, sir, so you go right ahead.
Yes, briefly. So I agree with the court's, I guess, initial questions on this is, number one, we have two sets of experts who disagree on what the standard of care applicable to Josephine Trillo was and whether it was followed correctly, which to me is a classic battle of the experts on medical malpractice case in the state of New York. Clearly questions of fact, and in fact, appellants spent most of their time arguing about whether or not there was a pulmonary hemorrhage, which to me is a question of fact. Our papers and our experts' affidavits go through multiple symptoms of a pulmonary hemorrhage. First, a bleed in general. She has a dropping hemoglobin and hematocrit. She comes in with
that like on about August 2.
It starts pretty quickly, Your Honor. Give me 1 second. So on the 27th of July, she has an 11.3. By the 31st, which would be the first day that she's seen by Dr. Cherney, her hemoglobin is down to 9.2.
No, I see July 29th. My notes, I got it.
Yeah, and it does precipitously fall. I'm not sure if there's other items in there. I'll rely on the record on that. But throughout those days, the days that we have marked in our papers, those were the hemoglobins. It is dropped. That is, along with the hematocrit, evidence of a bleed. The next question should be, where is the bleed likely coming from? And in her case, she has worsening oxygenation. She needs more O2. Her blood's not carrying enough oxygen. She's having difficulty breathing. She's requiring more support. The question should lead them to, is it from the lungs? There's an assumption in this case because of the nausea and the vomiting post-operatively She did aspirate. Our experts go through thoroughly showing how a chemical injury, especially with somebody with thrombocytopenia, somebody in this condition post-surgically, would cause chemical injury to the lungs, would cause bleeding and inflammation.
You said that word much better than I did, sir.
Thank you. She already has this predetermined inability to clot and heal and create blood product. So with that as the stage, a normal 10,000 rule of thumb that may be okay with normal, healthy patients is not the correct standard of care here. She's elderly. She has a bleeding condition. She's showing difficulties. You have to not wait till it gets so low that she could just bleed spontaneously. You have to be concerned that she's bleeding and not clotting already. So 50,000. As Your Honor pointed out, he did finally, once it gets down to 11,000, close to that threshold of just spontaneously bleeding, provide platelets, not red blood cells, but platelets. And she jumps to 38,000. He comes in the next day and it's at 19,000 and already dropped again and failed to provide it again. There are multiple points I would be happy to take the court through, but I think that those, of course.
I just read her age and you called her elderly.
Medically, she's elderly.
Just a little bit, but
Medically, she's an elderly patient with multiple
I'll accept
comorbidities.
distinction.
Thank you. I think the court.
We're all set, unless any of the members of the panel have questions.
Thank you for my time.
Thank you. Okay, last but not least on the calendar, number 462, Levine versus Lafayette Central School District. Justice Greenwood is recused. Ryan and Ms. Callahan, correct?
Yes, Your Honors.
Good afternoon. You've waited this long. We're here to hear your arguments. Go right ahead.
Thank you. May it please the court, Kevin Ryan of Syracuse on behalf of the plaintiff and appellant Laura Levine. Your Honors, I'll be brief because the issue in this case is very clear and very simple. It's whether Judge Fogel at the Supreme Court level erred in granting summary judgment to the Lafayette Central School District in a breach of contract action brought by my client.
Comes down to about 40 words or so. I'm probably a few off. Am I close?
Perhaps, yes.
I know there's a lot of the facts in the record in terms of what your client's understanding was entering into this deal, et cetera. But that's the focus of the appeal, as I understand it.
It is, Your Honor, and it really comes down to one simple issue, the fact that as a non-moving party, my client was entitled to every favorable inference and for the court to construe the evidence offered by her in this action as true. Now, what we have
along
here,
those lines, Mr. Ryan, but how does, I thought your argument was that this language was ambiguous, or am I wrong?
well, it is ambiguous, Judge, and it's subject to interpretation by the parties, and it's an issue of fact, whether it be by a judge in a bench trial or a jury to determine whose interpretation is the correct one in this case.
Okay, there's no favorable inference to your client, and that's sort of the focus I am. So we got to look at whether or not we agree with the Supreme Court that it's not ambiguous, or agree with you that it is ambiguous and construed according to the facts as you laid them out in your record.
Correct, because what we have here, Judge, is a contract that was drawn and interpreted differently by the parties. During depositions, it came out how one of the board members remarked how lucky the district was to get the services of my client, a seasoned school administrator who took the job for $30,000 a year.
Who performed well on the DSC program.
She's performed very well in every position she's ever had, except the race that she ran for mayor of Syracuse. That didn't work out too well for her, but in any event, Judge, she took the job for $30,000 a year, did not opt out because it was predicated on getting health care benefits for her and her husband for life. Now, it's clear that the Lafayette Central School District pays Medicare premiums for all of its retirees once they're off the payroll, and that's all she's seeking here. The same benefits that it provides for everybody else. And I know that the district will say that, well, that's not what we agreed to. We agreed to pay you under our plan and that's it. But again, what this is about is the Medicare premiums, because once my client turned 65, she went off the district's policy and onto Medicare, at which point she was obligated to pay the premiums out of pocket for her and her husband, who's now in his mid-90s.
Forgive my ignorance here. Maybe it's in the record and I just missed it. Is there no district plan that provides Medicare coverage?
There is, but they're not offering it. They don't offer it to her. And that's the rub of this argument. She should have been covered by that healthcare coverage for life.
An illusory contract offering her something that wasn't there to be had?
Well, it was there to be had because again, it's the same benefit that applies to every one of its other retirees.
But they didn't offer to her.
They did not offer it to her, no. And their position is that the Medicare reimbursement that they offer to their retirees is simply deducted from what their pension payments are. But because here they don't have any, they're under no obligation to make an affirmative payment to my client. And again, I think that's a distinction without a difference. I think what we have here is a case where there is an ambiguity of the contract. The judge found there wasn't, but in so doing, became herself the finder of fact. I think Judge Greenwood noted in the previous appeal that one of the attorneys was asking the court to make a factual determination. Well, Judge, with all due respect, that's what Judge Fogel did at the Supreme Court level. She made a factual determination that the contract was written a certain way, contrary to the understanding that my client had when it was executed and agreed to, and she offered her services. They got the benefit of her services, but didn't provide the bargain that she was supposed to receive. Judge, I'm not asking this court or any other to make a determination now as to what the proper interpretation of the contract is. It's simply an issue of fact. Now, we filed a demand for a jury trial. So what we would like to see is this case remanded back to Supreme Court. Deposition discovery is complete. Let's have a trial and let whoever wins at
What would the person be about it then?
whether or not whose interpretation of the contract was the proper one, whether my client believed properly that this was a contract that provided her for the Medicare reimbursement that the district provides every other retiree, or whether it did not. It's a really simple issue.
Okay, so you got to disabuse me of something here. I'm keep thinking as you're talking about this, they promised her this benefit and then said, but we don't have that benefit for you, or we're not going to offer it to you. It's as clear as could be what it says. I mean, I've read it and it seems clear to, but if that wasn't actually something that they could offer her.
But they can offer her because what they do.
But they just didn't. Is that what you're saying?
They just haven't, correct.
Okay, I see she kind of, reached out to them at points. There's some, about what she needs to do to be covered. And I don't know, it seemed like they were not talking the same language to each other.
There was confusion initially, and I think that once she retained counsel and understood what the obligation was, I think it was very clear that what she's seeking, and it's just what, again, like I've said before, what the district provides to all other retirees, reimbursement of the Medicare premiums. That's what this is about. She has Medicare now, and I think she might even have a supplemental benefit under the district's policy. But what we're looking for is, again, the reimbursement of the Medicare premiums. That's what this case is about. And has always been about from the very beginning.
Yeah, I think we have that, Mr. Ryan. Thank you.
Thank you.
Ms. Callahan.
Good afternoon, Your Honors. The lower court said the best evidence of what parties to a written agreement intend is what they say in their writing. So if you look at the contract in this case, I think what the plaintiff is asking this court to do is to rewrite her contract.
Okay, that's not what I heard counsel say. What he said is the contract says what it says, but then they failed to offer her the plan that conformed with what the writing said. Is that right?
No. So what the writing says is they will offer her and her husband, she will be eligible during retirement for continuing health, dental, and vision insurance coverage under the plans available through the district. And in such case, the district will pay 100% of the premiums for such coverage.
Okay.
So when she turned 65, she applied for Medicare. Now, she also kept her Excellus program. Excellus is the program that the insurance is offered through the district. So if she wants to get coverage under Excellus, she goes to the district office, she fills out the application, and through the district, she is able to get on that plan.
And did she get on that plan?
Yes.
Okay.
Medicare, she also has Medicare. Medicare is not a plan available through the district. Medicare, it's a federal benefit.
No, but it's not written in a contract that you're going to reimburse her for the Medicaid pay.
Correct. The word Medicare appears nowhere in this contract. Medicare Part B appears nowhere in this contract. If she wants to get Medicare Part B, which she did, you go apply through the federal government for Medicare, which she did. The district does not pay Medicare benefits for any retirees. What it does, which is part of the policy that was, it's on page 321 of the record. In 2018, the school board has this policy where if you're a retiree and you have Medicare, but you also have Excellus through the district, which is what the plaintiff has, they don't want you double paying. You're paying a premium to the federal government for Medicare, but you're also paying a premium to the district for that supplemental coverage under Excellus. So what the district does is it says, okay, we're going to give you a credit or a deduction, or they call it a reimbursement, partial reimbursement of the premium that you pay the district. And that's up to $96.40 a month. So that's what the retirees get. What they get through the district is they get a credit or a reimbursement or a reduction of the premium that they're paying the district for the district's insurance plan. The reason that the plaintiff doesn't get that is because she doesn't pay a premium to the
The district pays it for her.
Her coverage is free. The district pays 100% of her premiums for the plan that she gets through the school district, which is the supplemental coverage under Excellus. For her and her husband, they pay 100%. So she can't get a deduction or a reimbursement or a credit of a premium because she doesn't pay that premium. The district pays 100%. She somehow understood that the district was also going to pay her Medicare premium to the federal government. That is not something.
She's not using Medicare?
She's on Medicare.
She's not using it though, but she's using it.
She has two coverages.
Yeah, but she's using the Excellus. I go to the doctor, I have my Excellus coverage,
I think the two carriers work it out who's primary and who's secondary. One is the secondary coverage, one is primary
Right.
coverage, but she has both. And the one that she's entitled to under her contract is the insurance program that's available through the district. The contract says the district is going to pay 100% of the premium for that coverage, and they do for her and her husband for life. And as far as them getting a great deal because she agreed to work for $30,000 a year, she was also getting a pension at that time from a former job she had that she retired from of $102,000 a year.
That's separate.
Right. But she agreed to this because of that, but also.
She needed a waiver to get more than 30,000.
Correct, to get more than 30,000. But also at the time, she was represented by counsel when this contract was negotiated. The contract hired an actuary to see what the cost to the district would be to provide her with this benefit, and it was $269,000.
Which benefit?
To pay for the lifelong premiums for her and her husband. It was $269 for the insurance that is available through the district. Coverage under the plans available through the district. Medicare is not available through the district.
They had to quantify the benefit they were giving them.
Yes, but Medicare is not available through the district, so that is not what she was promised under this contract. What she was promised was that they would pay 100% of the premium of the plan that she chose that was available through the district, and they've done that. Thank you.
Thank you very much.